I pray your lordship can be taken after vacation, your lordship, because of notice has been served and they received the notice.
Undelivered notice,
That
undelivered notice came back.
the-
Postal tracking report
that
of
is
opposite party
insufficient.
flag be showing the item delivered.
Yes. Let them appear, your lordship.
Service and opposite party number. Anybody may appear also. How do you know?
No,
You mention it and get it urgent, and anybody may appear. Wait, I'll urgent it, but wait.
Yes.
Somebody may come and appear also. Yes.
all right.
Tick mark rakhi di sir. Appearance laga.
Yes, sir.
Yes.
Obliged.
Item 54 to 64.
My lord, item 54. I am praying for next week on behalf of Mr. Lalitendu Mishra. My lord.
These are 2016 matter.
My lord, there is an interim order, I know. My lord, short adjournment may kindly give.
What sort of, wherever there is no interim order, you are arguing. Mr. Mishra is arguing like this. Yes.
Next week.
I'll vacate this stay then.
My lord.
I'll vacate this stay.
No, my lord.
2016.
My lord, he is suffering from fever, my lord. Mr. Mishra. Kindly.
From 2016, you
Last chance may be given. Interim order.
Huh?
Patna is taken.
Yes, that's the whole problem. Once you take the stay, then all problems comes there.
That's why I am seeking for short
In a fresh
adjournment.
matter, Mr. Lalit Mishra will come and argue.
No, my lord.
And he must be arguing in some other court.
No, my lord. He is suffering
This
from
side of
fever.
vacation you keep.
Next week, my lord.
And so on behalf of Mr. Lalit Mishra seeking an adjournment. This is a matter pending since 2016 and interim order is operating. Please matter on such and such day, and it is made clear that if on that day if any adjournment is sought, the interim order shall be vacated. Yes.
My lord, interim order may continue.
Shall be vacated on that day.
Yes, my lord. Oblige, your
Yes.
My lord, item 55, my lord. Kindly taken over after vacation, my lord.
55.
Yes, my lord.
Same story here. 2017. 2017 matter, you have taken stay and seeking adjournment after adjournment. Reason of adjournment?
The senior told me,
Huh?
senior not available, so that's
Then I'll vacate, then you move application. Huh? Same order. Order. Yes. Next.
interim order.
1st of January. Yes.
65 to 72. 73 to 80.
My lord, 73 and 74. My prayer is to these two matters may be taken up today. If it doesn't reach, may I be permitted to make a mention at 3:30?
No, I think that everybody is seeking adjournment.
No, I am also hopeful that it will reach.
Let us.
But if not, then
If it doesn't happen, then
3:30.
yes.
My lord, item 72, my lord.
Hmm.
Kindly adjournment after vacation, my lord.
How many matters you are seeking
Two
adjournment?
matter, my lord. 72
Today.
Item 72, my lord.
Any interim order is there?
No, my lord.
March.
Right.
March last week. Yes. Yes, sir.
Item 1.
Item 1, I may be permitted, my lords.
For the opposite party.
Yes.
My lords.
So many adjustments they have taken already. Matter relates
But
to.
he say he is.
Should I not be permitted
What
to
is it?
submit, Mr.
Yes, Mr. Rao.
My lords? My lords, in this matter, my lords, it relates to a 138 enact proceeding, my lords.
Yes.
The petitioner filed a petition under section 311 CRPC for further cross-examination of the PW1, my lords. That is, that petition is annexed to, along with some questionnaire, my lords. Some 8
And-
questions, 8 proposed questions are there, my lords, page 13, my lords. Subsequently, by the annexure 3, that learned magistrate rejected the application.
PW1 is the complainant. PW1 is the complainant. Okay.
Yes, my lords.
Yes.
My lords. So the questionnaire is at page 13, my lords. So 8 questions are proposed to be put to the PW1, my
say?
lords.
What
But
is the check amount, by the way?
Check amount 4 lakh something.
No.
3,50,000. He has
3
not
lakh
seen the bill.
yeah.
3,50,000.
Matter may be targeted. Matter relates to 2019.
I will allow one opportunity and I'll impose a cost of something to be paid to you and target you. All the things I'll do.
But-
My lord.
I'll allow your application, right now. petitioner is agreed by the order dated 4/10/2023 passed by 11 Region Jajpur in ICC case number 140 of 2019, whereby his application under section 311 CRPC for recalling PW1, the complainant has been turned down. Turned down. What was the reason of turning down?
That reason is that it is a case of year 2019 millers. That is the
The trial court has rejected the application of the petitioner on the ground that sufficient opportunity has already been given to the petitioner for cross-examining the complainant. However, after availing such opportunity, the petitioner belatedly moved the application for recalling of the witness, and the case is the trial of the case is pending since 2019. Therefore, the application was not deserving merits. Accordingly, same was dismissed. Same was dismissed. Assailing the order, assailing the said order, the counsel for the petitioner submits that a single opportunity, at least a single opportunity ought to have been given to him to cross-examine, because he is facing the trial for an offence alleged to have been committed by him under section 138 for the dishonor of a check of the amount
of 3,50,000.
3,50,000. He further submits that he will not seek any adjournment in this matter, and he will complete his cross-examination on the single day. If one opportunity is afforded. Regarding to the statement made by the land counsel for the petitioner, the present petition is allowed, and the trial court is directed to fix a particular date for further examination for the PW1, and before putting the PW1 for the witness option. The proposed questions, the relevancy of proposed questions shall be examined by the court below. It is made clear that no adjournment on any ground whatsoever shall be entertained on behalf of the petitioner. The petitioner, subject to petitioner paying the cost of rupees 15,000 to the 15,000 to the complainant. The application is moved by him under section 311.
my lords, 15,000 will be too high, my lords. 15,000, my lords.
It is needless to say that the statutory command under NIA is to complete the trial of such cases of such nature within a stipulated time frame. Therefore, it is expected that the trial that is completed.
My lords, 15,000 will be very high, my lords. Lordship,
You give 3,50,000 check, make
My-
it 10. Yes, next.
Item 4 Miller, I am challenging the order for entire criminal proceeding on the ground of Miller compromise. Husband-wife dispute Miller, parties have come Miller. The whole difficulty is Miller, so far is other petitioners 3, mother-in-law, brother-in-law and a sister-in-law is concerned Miller, they are not able to come Miller. Only difficulty is that.
Why they-
Husband-wife question.
No, why they have not come?
See, Goare, Diora, sister.
Address is Ganjam. You have given Ganjam address.
ବେଲେ ସେଠି ପ୍ରାଇଭେଟ କାମ କରୁଛନ୍ତି ଆଉ ଶାଶୁ ଦେହ ଟିକେ
No,
ଖରାପ
who has come then?
ତମ ହଜବେଣ୍ଡ ଆଣ୍ଡ ୱାଇଫ ବୋଥ ହେବ ମେନ୍
Suresan.
ସୁରେଶନ ଏସିଓଲ
Suresan Sahu and
Oliver Naik.
what is the item? Item 2 has been adjourned, sir, on request.
No, but I am sitting here, nobody mentioned if it is urgent, I have no objection. But
I'll record your presence, sir. I'll record Mr. N.C.
That's
Panigre, senior counsel, appearing for part number 2. All
the
those
only
who-
thing is,
Yes.
will your lordship still will hear this or not? Because your lordship recused that case, Deepak Gupta case. It is that arising out of that case. that Ulivuru Mines case. I have no objection. I will be glad if you.
I'll simply adjourn. On that day, you remind me, I'll not hear.
Okay, okay. No, I have no objection.
Let us see. On that day, I will see. Okay.
Item 5.
That was for the March. March. Yes.
Item 5. In the case your lordship may kindly see the prayer matter.
Prayer.
Man.
Yes.
That is it. Page my lord 7. Please to direct the forest range officer Jagat Singhpur to release the vehicle Tata SC. He has also filed a petition CRLM, page 9 your lordship may kindly.
Page 9.
Annex 1. CRLMP filed by the same person, Prasanna Kumar Mahapatra, under the para 2 minor. Under the aforesaid facts and circumstances, therefore declared that this honorable court may graciously please to issue notice to the opposite parties and after perusal of the purchase shown, be further pleased to direct the forest range of to release the vehicle minor. There, then next page your lordship may kindly state 10 minor. Government Council for the State, referring to the affidavit of the range officer Jagatsinghpur, permits that in meanwhile the seized vehicle in terms of the order passed by the authorized officer cum assistant conservator of forest, the vehicle in question has been confiscated. In view of this, there is no further scope for the court to exercise its jurisdiction under CRLM.
So confiscation has taken place.
He will take my lord report sheets before the Lawrence Assembly.
What is he asking then?
Release of that vehicle, man. Same prayer there and same prayer here.
Pass it over.
My
Remind me. It can be disposed of. Yes.
Item 6.
Yes. What is he asking here?
This is a case.
Cognizance.
Cognizance. And imbue has been issued.
I'll use the order. I'll cancel the NBW and ask him to argue there before court of.
And imbue, my lord, because he has mixed something for which the prudence have suffered. So lordship's on its own merit, your lordship's name.
Okay, let him come. Yes,
My
pass it.
7.
May I present? Offense under section 52A.
Yes.
Of Odisha Excise Act.
Yes.
The present petitioner is the owner of the vehicle and the driver who is the on 16/10/2022 during patrolling the Odisha Excise Police Tigriya got reliable information that one person of Ballyput area transport ideally for a blue color Swaraj Mahindra tractor during number 24. And the excise police is there and found 46 blue color plastic jerrycans, each contain 35 liters of ideal liquor. It is for the they reached the spot and the driver fled away from the spot. And the present petitioner is the owner, but it is apprehended.
What do you want?
Bail mail,
Your bail application is rejected.
No, anticipatory.
No, these are the offences. Any day you can go and get a bail. What is the problem?
Apprehend ladies, he also very suffering. And they apprehend only bail.
Bail, I can't give the bail. I can only give observation. That
Interim protection, court.
let him go and surrender till I'll protect him till in this month only. Petitioner is seeking, although the petitioner is seeking quashing of the entire criminal prosecution arising out of 2ACC case number 58 of 2022, initiated 2022 for release for commission of offences under section 52 small a small I of Odisha Excise Act, but he submits that his client being his lady shall appear before the court, appear on the court on or before 31st of December also, and seek remedy available to him under law. Till then, no court action shall be taken against them. The allegation against the allegation in the complaint is legal allegation. The petitioner appears to be the owner of the vehicle which has been used for the commission of the grant, which has been used for commission of grant. She is a lady of 37 years, and she is apprehended. Lady of 37. Therefore, the prayer made by the petitioner deserves merit. Accordingly, the petitioner, although the petitioner is dismissed, dismissed of this case, liberty granted to the petitioner to raise all the points before the court stage. At the same time, no court action has been taken against the petitioner till 31st of December. Subject to the petitioner appealing and resorting to remedy available to him, available to her under law, before 31st of December. Yes,
Item 9.
allowed. Yes.
May I please, my lord?
And before 31st December, you till 31st December, I will protect you. You go and apply for it.
My lord, on last occasion on 5/12/24, your lordship has directed my learned brother state to obtain injury report. Here is my lord, father is the informant, son is the petitioner. My lord, it is alleged that
Father and son.
my lord,
Yes, counter case also there.
You are for the
I am for the petitioner.
son.
I'm for the information.
Yes,
Yes. You settled the dispute or what?
yes, my lord.
Have you settled the dispute?
Already done.
Show me the injury report. What are the offences? 307.
Yes,
328 of IPC.
You beaten your father.
yes, father and
No,
son.
my lord. They have administered the poison, my lord, in the
Yes,
water bottle for which he was admitted in the hospital.
Huh.
That is the
Yes.
That is the allegation.
And
Injury, yes, sorry.
that
Oh,
report, my
medical
lord,
report.
he was treated in a hospital.
Then
WhatsApp he has sent and just now that's C hospital, your lordship.
when he got admitted, when the incident had taken place?
My lord.
Incident taken place.
This incident taken place on
For
22/8/2024, my lord. 22/8/2024.
Incident.
କାନକୁ ଘରେ ବିଶୃଙ୍ଖଳା କରି 22/8।
No. FIR is registered on 4/1/2023.
4/1/2023, my lord. Sorry.
Huh.
And
When he
4/8 he was admitted in C hospital, your lord.
when you are discharged.
Discharge,
that charge sheet is yet to be submitted, my lord. 1 year and 10 months have been passed.
ଏବେ discharge ହେଇଛି କିନ୍ତୁ ରେକର୍ଡ ହେଇଛି ତା ଷ୍ଟେଟମେଣ୍ଟ ତା ତଳେ ଅଛି। ପ୍ରତାପ କୁମାର ବେହେରା ତା ତଳେ ତାର ଷ୍ଟେଟମେଣ୍ଟ ଅଛି। ଭାଇ ଭିତରେ dispute, but ମାରିବା ନା ତ ମୋର ପାଣି ବୋତଲରେ ବିଷ ମିଶାଇ ଦେଇଥିଲେ ସେଦିନ ତା 31/12/2000 ରାତିରେ ମୁଁ ଚାଉଳ
When you are discharged, I want to know.
that part because sir suddenly the case is solved and he has not sent the instruction for which I have told him to at least
How many days he remain in the hospital? At least that much you tell me.
party
I want to know the severity of the
poison.
poison.
My lord, it is allegation that he has been administered poison.
I know what kind of poison and what are the whether it is serious. How many days your father remained in the hospital? What are you doing, by the way?
No, ma'am, not my father, by my elder brother.
Elder brother. Okay. What are you doing, by the way?
I am doing a business, my little business.
ଚାଉଳ ବିଜନେସ କରନ୍ତି ସେ ଗୋଟେ dispute ଥାଏ।
And last
Where
occasion,
where are they?
my lord,
Where are they?
last occasion they were present in the court.
Huh?
Your lordship had asked for the injury report. Today they are not present. If your lordship asks, then I will.
What do you say? Okay, just ask what is the severity? Nothing is coming for.
Lordship will call for the CD.
Nothing is there, ma'am.
Not survive, lordship will call for CD.
I see it is a fight between two brothers.
Right.
I'll quash it, no problem. But I want to just exploring the possibility of heavy cost
তার
on.
কোন পয়জন না নেই আইসিইউ অ্যাডমিশন হইছে লিখি দিন
That's what I wanted to know. See, it appears 12/4/2024 means from 4th to for 8 days he was in the hospital. It appears. I don't know.
So I'll my lord lordship se
How many days he remained in the hospital?
Monday or Tuesday your lordship may
Keep it in Monday. Monday, keep it Monday. And bring them on Monday. Bring them on Monday.
Monday na Tuesday
Yes.
I'll bring them both, my lord.
Both. Yeah.
Tuesday as
Tuesday. Okay. Tuesday. Okay.
Madam Chair,
Yes, sir.
this is a case my lord SC Act is there, so they are saying message is settled.
Sorry, ma'am. Both the parties present here, ma'am, case and counter case. The matter is
Case and counter case.
Yes and counter case.
same allegation, same FIR, same charge sheet, my lord.
No, same incident is same.
Same.
And you filed a case against them, they filed a
They
case
file
against you.
against
That's what.
Yes.
my lord.
Allegations are same.
Same, my lord. Charge sheet also same. Everything.
Charge sheet is same means
Same.
allegation same. Charge sheet may
Allegation
be
with the
different.
offense my lord.
You say that. Yes.
Parties are present, my lord.
Where are they? All the same parties or different parties? Parties are different.
Yes, ma'am.
Different.
In my case, they are accused, and in
Yes.
their case, I am accused.
Mantu must be the accused in the other case.
Montu is the informant in one case and accused in another case.
Yes, who is Mantu?
item 11,
May please, Lord. My lord, petitioner,
Devendra, it is because of your lordship's judgment. That some condition has been imposed while releasing on the truck that transporting the cattle my lord. Let him go through their judgment.
my lord has also.
And I say that judgment overruled each other.
Have you read that judgment?
Yes, my lord. I have-
ସେତେବେଳେ ଆମେ ନୂଆ ଆସିଥିଲୁ ଆମେ ସେ ପାର୍ଟକୁ ଯାଇନଥିଲୁ ସେ ଫର ଦ୍ୟାଟ ଇଜ ଗୋଟେ 2 ଲକ୍ଷ ଟଙ୍କା ଲordship
Here, my lord,
subsequently that order
To begin with, 2 lakh rupees you deposit and go and move application. I have not given anything.
that order may be passed, my
whether
lord.
that has been challenged or not, that's very bad because
Which one? No.
No,
What I did is, what is the amount here?
Here, my lord, 15 lakhs, my lord.
15 lakhs.
Yes, my lord.
Then in this case,
4 lakhs.
4 lakhs are 50%. Here is pay 4 lakhs, then 50%.
Yes, my lord.
4 lakhs and 50,000 rupees. That was the condition.
Yes.
So I said that 50% you pay and go move application.
Yes, yes.
Here also you pay 50%, go move application.
Yes, yes.
And that will be decided on the basis of my judgment.
Say order card cancellation file
No, file in, sir. Gadi release.
This
Gadi release.
Which order you are talking about?
that order of release my lord might have challenged in the middle.
No, there is an order of release with some condition.
My lord.
What I am saying is 50% of the condition amount he has to deposit and move an application before the trial court. I am not saying anything.
Yes,
And the
yes.
trial court, on the basis of the judgment passed by me, that on that basis,
Let him undertake how many days is required for another 50%. That will be better, man.
no, that will be, he will move application for variation of the order.
Yes, my lord.
The court may vary, court may not vary.
It order they will vary, man.
No, I will see, I have said that shall consider on merits.
Once my lord, your lordship say, my lord.
And may modify the condition as it may think
because
important.
because your lordships knows that if you once your lordships may although there are word may, but that impact heavily to the.
So what do you suggest? What is it?
Let them take on file and undertaking, then within stipulated will file the right amount as per their judgment, my lord, lordships.
My lord, this order may be passed, my lord. I will have. My lord, but since my lord, 2000, my lord, since April 2024, the vehicle is then in their.
So
custody.
that what I'll say is, he will, the trial court shall decide the application on the basis of law operating in the field. I'll say that. Petitioner is agreed by the order dated. What is that order? Order dated? The 30th November 2024, passed by
JMFC.
the JMFC Telkoi in CMC number 36 of 2024, whereby although although there was a direction for release of the truck.
Running page 25.
However, with certain conditions. The petitioner is agreed by the condition number 2, 3, and 4. 2, 3, and 4, which reads as under 2, 3, 4. Counsel for the petitioner has relied upon the order dated 13/11/2024 in CRLMC number 3506 of 2020. In that case, the vehicle was released with the direction to deposit 4 lakh rupees. 4 lakh rupees. The petitioner had approached this court, and this court, by asking the petitioner to deposit 50% of the directed amount, may move application for various the order insofar as the remaining 50% is concerned. The counsel for the petitioner submits that similar order may be passed in the present case. Where is the condition?
My lord, running page 25.
25.
Paragraph number 3, my lord.
25. 23, para 3.
Yes, my lord.
Yes.
The petitioners have paid 15 lakhs
Where is
only
it?
to see page
Para 3. Para 3. Yes.
Baitarani Gosala.
Condition number 1.
Condition number 3.
Regarding head to Mr. Jenna, the counsel for the petitioner, however, opposes the prayer made by the petitioner and rely upon the judgment of this court passed in CRLMC 5310 of 2023, Dhyan Foundation versus State of Orissa and others. He submits that the petitioner, if at all, is entitled to relief, it has to be on the basis of the judgment of this court in Dhyan Foundation Supra. So regarding head to the submission made by the parties at the bar, I'm inclined to modify the order to the extent that to begin with, the petitioner shall deposit 7.5 lakhs, 7.5 lakhs with the before the trial court within 15 days hence, and for the remaining 50%, and for the remaining conditions, he may move an application for variation of the conditions. Variation of the condition. If such application is moved, the same shall be considered with the trial court strictly on the basis of the law occupying the field, field, and on the effect of the case. It is also made clear that this court has not expressed any opinion on the merit of the case. Allowed. That is, yes.
Item 12.
Lordship, I have challenged the order of the learned Justice Ganjam at Barampur, refusing my prayer to deposit the 20% of the fine amount under section 140 of NI Act. The item number 12 and 13 are the similar. Because of 2 cases, we have filed 2 cases.
You are the accused.
I'm the accused.
Yes.
I got conviction before the trial court by the JLC and sentenced.
In the first case, what is the check amount?
Check amount is 10.
Item 12 and 13. My lord, I am appearing for the complainant, my lord.
Yes.
My lord, one copy of the application, my lord, served on me.
What do you want? You can't pay.
I raised the learned trial appellate court to exempt me from that deposit as per the decision of the Honorable Appellate
No,
Court.
it doesn't say. It is only say it's fact to fact you have to examine. It is not a blanket. It is not a blanket.
I have got an
thing that
exceptional case. I have got an exceptional case. I have filed the petition.
What is the
for
exception? What is the
Because
exception?
the check is of 2022. The conviction is 2023, and the fine amount is the twice. It's a disproportionate punishment on me. That apart, it's a lady, and she is a housewife. And the case of the petition complainant is that she gave me 22 lakhs in cash to purchase my house. That is the allegation. And the most sad thing is that the advocate before the learned trial court has not examined the complainant. On the date of judgment, she changed her advocate And on that day,
You should have moved
I
application under.
have, on that day, I moved two applications before the learned trial court to recall the PW1 for cross-examination, and another application disputed the signature. This is signature is not of mine. Even in the accused statement, I have stated this is not the signature of mine.
Yes.
Filed a petition to send the signatures to the handwriting expert.
And both the applications
Both the
rejected.
applications were rejected, and I have been found convicted.
On the same
Only
day,
sentenced to only
Same day. you have been convicted.
same day.
Yes.
And only conviction is that no rigorous infringement or simple infringement. Only conviction is that to pay the fine,
Double the amount of the check.
double the amount of the check. So within a period of 1 year, I have been.
So deposit 10%.
If
I'll vary to, or you deposit 10%, your appeal will be heard as expedition.
maybe for 5% because I'm a housewife. How far it is believable that
No.
22 lakhs he has
See,
paid?
you say that double the amount. So therefore I reduced to 50%.
20%. 20% is the.
So therefore I reduced it to.
20% is been ordered by the learned.
What is it?
Appellate court, my lord, directed, my lord, on deposit of 20%.
What do you say? Is there any chance of settlement?
We'll go for settlement.
Why don't you go for settlement? Let him deposit 50% and explore possibility of settlement. What is the check amount in both the cases?
In one case, total is 22 lakhs.
22 lakhs.
10 lakhs, 22 lakhs.
22 lakhs. You take 10% to begin with, and I'll relegate it to mediation.
It will be very hardship for me because I'm a housewife. It will 5% as a.
And how will you then negotiate?
Overcome the.
If you in the mediation is even successful, you have to pay something, and 10% you are paying, that will be adjusted obviously. If you want mediation, you will settle the dispute. Any case you have to pay something. Not that if they leave it. So 10% you are paying, that will be adjusted. That is the kind of installment. So it's better that you pay 10%.
After deposit of 10%, the matter will send to.
I'll ask the appellate court to explore the possibility. And thereafter hear the appeal. And dispose it. Okay. Petitioner is
Time of
agreed
1 month may
Yes.
Time of 1 month may candidate.
Yes, yes. I'll give that time. Madam, petitioner is agreed by the order dated 22/6/2024. Passed by the Sessions Court Forampur in Criminal Appeal number 41 of 2024, whereby while admitting the appeal for the petitioner against the conviction and sentence order passed by which is the order passed by passed by Leonard JMFC on 17/5/2024, directed the petitioner to deposit 20% of the compensation amount as per section 148A, capital, yeah, 148A of NIA. The the matter was heard at length, and the parties have ultimately agreed to the term that the petitioner to begin with shall pay 10% of the compensation amount within 4 weeks, and the matter may be relegated to the mediation cell for exploring the possibility of a settlement. Accordingly, the accordingly the petition is allowed. The petitioner is directed to pay 20% of the 10% of the compensation amount to begin with, and the appellate court what is the appellate court number? Sessions Judge, Leonard Sessions Judge Barampur.
Yes, sir.
And Leonard Sessions Judge Barampur is directed to relegate the matter to the district mediation center to explore the possibility of out of court settlement. If the settlement in any case is unsuccessful, then the appellate court may proceed to hear the appeal in which it is possible. This observation, the petition is disposed of. Yes.
Please mention about that 1 month time to deposit.
Yes, I have given this. Yes. Both the matters are all same order, same. Yes. pay 10%, the appellate court will send it to for mediation. You try for mediation. If mediation takes place, nothing like that. It doesn't happen, then
It will be on the
you have to argue what to do.
Appeal will have, my lord, on
But
merit.
you, better that you should settle.
My lord.
Fix some settlement, installment and finish it up. Yes.
obliged.
14.
14, my lord, may I please your lordship.
14, huh?
lord,
This is
crossing
12 and
of-
13 gone.
My lord.
Yes, you are 14.
My lord, crossing of proceeding, my lord. My lord, here is the case, my lord, threatened over telephone, WhatsApp call. And the magistrate to cognizance 294, 506, 507, 34 IPC. The allegation is that on the date of
Nowadays, lokaiti, robbery, everything is happening in the mobile only.
I was at
nobody
your
doing
lordship.
anything except
No, no.
in
Your lordship
mobile, all
kindly
things
see
are being done.
page 12. Your lordship kindly say the no voice has been recorded. The खाली से आगे allegation दे के लोकनाथ रेड्डी so and so गत दिन तले I was at America, my lord. I was at America.
I'll issue notice, you bring him, we'll see what can be done. What is the stage? Investigation going on.
No, lordship charge sheet filed. Charge sheet filed. My lord, I prayed for my lord stay of further proceeding.
No further proceeding unless you satisfy me. Why said?
294. My lord, so far as the 294, it must be in publicly. It's allegations, my lord, over WhatsApp call, my lord, using slang language over phone.
506 is made up.
506 and 294 and 507 34.
Then
My lord,
506
not in the public. What's your lordship kindly, my lord, visualize the case. Every WhatsApp club is private, my lord.
Show me the allegation if you want to. I want a state. Let us see. Show me the statement
Page 12.
Statement of the victim.
Informant, page 14, your lordship. S. Lakshmi Swami, your lordship.
1-4. Read it.
S. Lakshmi Swami, Swami S. Pura Gramo Pita.
Don't read the name and all.
Yes,
Read
sorry,
the relevant part.
थाना गोलचरा जिला गोलंतरा जिला गंजाम आजिता 10/9/23 করে উপরোক্ত মোকদ্দমার তদন্তকারী বাবুଙ୍କୁ দেবা আমার মৌখিক বয়ান এই কি যে আজি সকাল 10:24 AM সমୟରେ ଆମ ଗ୍ରାମ କେ ନରସିଂହ ମୂର୍ତ୍ତିଙ୍କ ପୁଅ କେ ହେମସୁନ୍ଦର ଆମେରିକା ରୁହନ୍ତି ପ୍ରେଜେଣ୍ଟ ପିଟିସନ
WhatsApp କଲ୍ କରି ଅସଭ୍ୟ ଭାଷାରେ ଗାଳି ଗୁଲଜ କରିଛନ୍ତି
ମୋ
ମୋ
ସ୍ୱାମୀ
ସ୍ୱାମୀ
ଅଛନ୍ତି ସେ ନଥିବାର ଜାଣି ମତେ ଫୋନ କରି ଗାଳି କରୁଛନ୍ତି ଆଜି ମତେ ସେମାନେ କଲ୍ କରିଥିଲେ ମୁଁ ଉଠେଇ ନାହିଁ ତାଙ୍କୁ ଏବଂ ତାଙ୍କ
She is a lady. If you do, husband is there in the America and you are threatening her.
My lord, your lordship kindly see the timing, my lord. 10:24 ହେଲା ଆগে ଆମେ ସେଠି ଆମେରିକାରେ ଶୋଇଛୁ. And it's a my lord, no, my lord, recording.
Issue notice, written also. In the meantime, the proceeding, and I am sending it to. What I'll do is, I'll send it to mediation. You go and
My lord.
tell sorry, whatever, and finish it up. Where is that place? Where is that place?
JNFC Cognizance Barampur.
Barampur.
Medicine center.
Medicine center. You go and finish it up. At least you will be peacefully living. Apology and finish it up. Right on. The petitioner is accused in so. Allegation against the petitioner so. After investigation, charge sheet has been filed in the present case on 28 April 2024 for alleged commission of offences punishable under section 294/506 or 507/34. I have and thereafter the learned court below has taken cognizance of the offences by order dated 29/1/2024. 29/1/2024. I perused the allegation the documents form part of the charge. The allegations are minor in nature, and therefore there is all possibility that the parties minor in nature. The counsel for the petitioner also submits that there is a possibility of settlement in the matter. Settlement in matter. Therefore, The parties are therefore therefore the present matter. Therefore, the parties are relegated to the district mediation center of Barampur. District mediation center, Barampur, for exploring the possibility of settlement. The coordinator for the mediation center is directed to issue notice to both the parties and explore the possibility of a settlement between the parties and submit a report before the court below, before the court below, before the court below, before the court below. Till then, till the mediation process is completed, the trial court shall not proceed with the matter. Shall not proceed with the matter. The petitioner is given liberty to approach this court if cause of action still survives at any stage. With this observation, the petitioner is disposed of. I stated, go explore the possibility. If any cause of action still survives, you can come. Okay.
It's dispose of my lord.
Dispose of why to keep it. Yes.
Item 15.
My lord, last occasion, status report was called for, my lord, from the Lalin court.
Yes.
Flag is the status report.
Huh?
The lordship flag is the status report is in the.
Is that?
And here is the case is present informant search for an early disposal of the city case so and so lordship.
Hmm?
The present petition is the informant lordship.
Status
Has not yet commenced.
Yes, ma'am. My lord, case, my lord, FIR was issued, my lord, on 14th of December 2020, and 15th of September.
There are 10 accused persons.
Yes, ma'am.
And
Only I am a limited player, my lord, kindly expedite the trial.
that's the problem is 10 accused person. What are these their
And my lord,
status,
only-
whether all of them are on bail or
Yes,
not?
my lord. 12 witnesses are there, only 12 witnesses there.
That's right. But all the 10 accused persons are the what do you call? They are on bail.
Out of 1 person is pending, my lord, and 9 persons are on bail, man.
Then it has to be splitted.
Yes, my lord, it is.
When all this process takes time, now I can't simply say that.
But my lord, every date the accused person, advocate of the accused persons came and filed a time petition, my lord, on various grounds.
Well,
And it's pending
I'll
since-
just close that part at least. Then, pursuant to the order dated, when I asked this, pursuant to order dated 21/11/2024 of this court, the learned SDJM Udala has submitted a report dated 9/12/2024 inter alia stating take paragraph. The petitioner is the informant in the present case and seeking indulgence of this court for direction for the expeditious disposal of the trial. He submits that out of 10 accused, 9 of them are on bail and 1 accused person has not been admitted to bail as well. The accused persons are repeatedly seeking adjournment before the court, we can object to get proceedings before the trial court procrastinating. Therefore, finding no way out, he had to approach this court with the prayer for expediency. Nothing is coming to the fore on the record to establish as to whether the accused persons are indeed causing delay or not. Without going into the without delving upon the contention raised by the petitioner, I am of the view that a criminal case of the present nature needs to be disposed of as expeditiously as possible, and which is the mandate, which is a constitutional mandate. Therefore, the trial court is directed to do well to see that the trial is concluded as expeditiously as possible. Neither the accused person, neither the prosecution nor the defense shall be allowed unnecessary adjournment on any pretext. on any text henceforth. So as to curtail the further debate in the question, further debate. With this observation. Yes.
16,
May please your lordship.
Yes,
Milord's petitioner was working as a technical assistant in the Gram Panchayat.
yes.
He was alleged to have been involved in a case under section 13(1)(d) 7 of the PC Act.
Yes.
Now almost all witnesses have been examined and IO has already been examined. Thereafter, a petition was moved to examine 3 more witnesses. That having been allowed, I have approached your lordship. IO has been examined.
Who are you?
I am the accused. I have already been removed from the service.
Whose application was allowed? Prosecution.
IO has filed an application. Prosecution has filed an application.
Yes. To examine?
Another 3 witnesses, they were neither charge sheet witnesses nor anything of that sort.
Yes, show me the impugned order.
Impugned order, my lords. Annexure 5 at page 101.
What are the reasoning?
Your lordship may see operative person on perusal of the case record as 103, page 103. It is found this is a case of the year 2015. 13(2) read with 13(1)(d)(7) of the Prevention of Corruption Act. Accused is now facing trial in this case. Charge sheet has been framed on 31/10/19. In the meantime, 10 witnesses have already been examined. At this stage, court has forgotten that IO has already been examined. At this stage, PP Vigilance has preferred to issue summons to the then Sarpanch, so and so, father of ward member, as witnesses of the prosecution case.
The court says that they are relevant witnesses.
But they were never
Because the work order was.
They were never shown as the charge sheet witnesses.
But is there any legal bar?
No legal bar, your lordship is procedure. IO has already been examined.
Maybe.
But
See,
question
maybe.
is,
See, the reverse is also, reverse what we do generally. What we do. If accused come, we generally allow one opportunity. I will restrict them to conclude the evidence within one hearing also. Because it is left open like this.
I am not aggrieved by anything. This fellow has been removed from service. He is not getting food to it. He just cried before me. For that reason, I have filed everything and made a brief like this. But
Therefore, I'll restrict
can this way the prosecution should run? Well, investigating, he should have verified who are the relevant witnesses. Prosecution should have shown who are the relevant witnesses. They don't show them. They don't examine them. IO gets after 13 witnesses, IO has been examined. So normally the IO is the last witness in prosecution matter.
That's right.
So it is only harassing a man. Here, the way he came to me, I will not describe it.
That's right, sir. What is the legal, whether it is legally tenable or not, that is
legally tenable in the sense, it is the
emotional issues are different.
It is a searching evidence. They have failed in every matter. They have found no evidence. They want to frame new people and create evidence. That is the whole thing I have come up with.
What do you say?
This is searching evidence.
161 recorded. Respect of the
These people.
People say charge sheet in order to that has been mentioned. So in any case, trial court has held that and it is found that it's for the jurisdiction of the case. How we will be prejudiced?
I know that.
Your lordship may see. The petition at page.
Because these witnesses 161 statements were recorded.
But this says the inadvertently the IO could not show them at charge sheet.
Yes, that's
but can it be a ground, my lord?
But they were examined by the.
I do not deny. If they were examined, they should have examined them. But
I'll restrict the recording of the within 1 day.
Any case. What is the harm caused to?
Harm caused, my lord.
Harm means, see, harm would be any material may come. Today there is no material. That perhaps the reason the PP might have thought that there is a case of acquittal. So I want to bring further evidence. That's what is the case.
even if a person has not been cited as a witness, at any case.
That's there, that's a simple law, that's, need not labor on that.
But after
I have seen it.
Millards, after the IO, normally no witness is examined in the criminal trial. At little knowledge I have in the criminal trial, IO is the last witness because the confrontation cannot be done. Who will be, whether he has said this before the IO or not, how can it be confronted before, whom will be confronted?
Yes. Yes, I'll restrict the examination.
If necessary, IO has to be re-examined, then if I suppose that, yes, please don't. Hear me, then tell me.
He will call the IO.
Then confrontation, how many
Evidence comes, he has to confront with the IO. So when the trial starts when?
Because your trial started in 2017.
15.
Charge framed in 2019. Now it is 24. The man is removed in service long back. He is a man from Puri. He is running to Venkata.
What I can do is, I will direct the trial to be concluded within a stipulated time frame.
I have no.
And one opportunity, whatever the opportunity is given, it's left open. I'll give only one opportunity. I'll restrict the witnesses to be examined on the same day, and your right is open to resort to the remedy available to you, and with a cost.
And
with a cost. Actually, I'm doing it for the. I'm doing it for a defense. I'll do the same thing for you.
I have done this case pro bono. Your Lordship may see the brief, because I have not kept any records out from the court.
That's right, but
that man was cried before me like a child. He has been removed from service.
What to do on the basis of emotion?
I'm not saying anything. Well, I'm not saying anything about the justice, but with the way the prosecution is being conducted.
Yes. The petitioner is accused in FIR number so and so. He has been facing the trial since 2015 in TR case number in the vigilance GR case number 28 of 2015. He's agreed by the order dated 25/7/2024 passed by the Special Judge Vigilance Dekanad, whereby the application of the prosecution under section 311 has been allowed and 3 witnesses were recalled.
Yes,
3 witnesses
yes,
have been recalled. You tell me one thing, why 3 witnesses? BDO, Sarpanch, who else?
BDO, Sarpanch and BDO. Now 1 member.
And you want to prove same thing? Where is the questionnaires?
Questionnaire not given.
No. That's right. But why you? What are the point you want to prove? See the impugn order. You can examine any one of them or 2 of them. Why 3?
Why I am saying so? They have not questionnaire comes. If they are been examined and some questions are left.
You examine BDO and Sarpanch. Put an end to it. 1 official witness, 1 private individual. BDO, Sarpanch.
Father of the complainant who has executed the work. So he should be examined.
PEO. No. You want to examine BDO, Sarpanch and PEO. BDO, Sarpanch and PEO.
Sarpanch, someone Sarpanch named Sharad Kumar father, complainant's father. Sarpanch, complainant's father, they have executed the work. That is Bharadwaj Pradhan, Sharad Kumar Pradhan, and Bharadwaj Pradhan, and Ako ward member into the jail, Johnny Asli.
How many witnesses you called for? Let us answer. Where is that? 103.
Second part.
Summons to the Sarpanch. So
Complainant's father, Bharadwaj Pradhan, and ward members of the 3 ward members also, Johnny Asli.
and BDO also.
BDO.
Where is that video?
It reveals that the work over the
Page 98, your Lordship may see. He has said whom he wants to examine. Page 98.
What was your application? Let us see. What are the application?
Yes,
what is
pressing the application.
Where is the
I'm
application?
pressing the application. Page
Show me
98,
press. Show me press.
pressing.
Prosecution should allow.
Page 98, paragraph 2.
The video could acting on.
He then Sarpanch, namely Saroj Kumar Pradhan, son of late Jaladhara alias Jaya Pradhan, of village Mahabirod, so and so, district Deccanal.
And GP, Parallel GP, namely Garika Bandhu Mishra, Vinay Sahu and Madhusudan Sahu are the material prosecution witnesses essential for judge decision of the case. This is their question.
So then, video, why it is allowed?
The video for
Now you come to 103.
103 video.
Is allowed whom?
IFR itself is that what video
Then you are calling Sarpanch.
Three. There are three only.
One Sarpanch and ward member
Yes.
is complaint father. So then you member, you forget about member. Then the Sarpanch and the father of the complaint. Right. Record. 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 For someone for deposition from the Mr. Das, Land Counsel for the Senior Counsel for the petitioner submits that these witnesses, those who have been freshly summoned, has not been made prosecution witness in the charge sheet. Therefore, after the examination of the IO, when the trial is at the fake end, the prosecution should not be allowed to introduce fresh witnesses so as to bring additional evidence which has not come on record as yet. Mr. Maharana, on the contrary, submits that these witnesses, the statement of these witnesses had were recorded by the investigating officer under 161 CRPC. However, inadvertently, they were not included as prosecution witnesses in the charge. At the same time, he submits that since there is no legal bar to examine fresh witnesses, therefore the application of the impugn order cannot be found faulty. Cannot be found. I have carefully gone through the record placed before me and formed the conclusion that instead of summoning 3 witnesses, it would have been suffice for the prosecution to examine 2 witnesses. Or, yes, 2 witnesses. I mean, suffice for the prosecution to examine 2 witnesses, namely the Sarpanch Saroj Kumar Pradhan and the father of the informant Bhardwaj Pradhan, who alleged to have executed the work in subject. I am alive to the fact that the prosecution has sought for summoning 5 witnesses. However, the trial court has only allowed 3 witnesses. 3 witnesses. Huh? For all the since the petitioner has been undergoing the rigors of the trial since 2017 for an FIR registered against him in 2015. It needless to say that the trial should be concluded as expeditiously as possible. In order to achieve the same, the prosecution needs to conclude the evidence, which is conclude the evidence by summoning the 2 witnesses on the same day to be fixed by the trial court without unnecessary seeking adjournment. It is also not precluded for the prosecution to lead further evidence if necessary. Necessary after the examination of the 2 witnesses sought to be summoned. This observation, the petition. Yes. Number is 2017.
17 ରେ ସେଟା clear number ଅଛି ନା charge ଟା ନେଲା ପରେ
Acha. He's all right. He's 2017. Yeah.
17 ରୁ
No,
ଆରମ୍ଭ ହେଲା।
I have done both the things to balance here. Yes.
17.
3 copies.
May I please, my lords. Challenging the order of cognizance by the
Eh,
annex.
one official witness you will do, one private witness. That's enough. Enough. Yes, yes.
My order of annexure 4, my lord, order of cognizance challenge, my lord. Very interesting case, my lord. Here, the petitioner of the same allegation already arrested, faced the trial, got acquittal order by the annexure 3, my lord. Lordship kindly have a glance. Annexure 3, the acquittal order already passed by same court. Again, my lord, second FIR log same allegation.
Show me both the
My lord.
allegation.
My lord, allegation
In the
lordship.
case where you got
Again.
acquitted,
Again.
what are the offenses?
My
420, 467, so and so, so and so.
Annexure 1,
Here also one
annexure 1 is a fair, my lord.
FIR. Yes, read it.
Lordship got it, annexure 1, that is.
Tell me the allegation. What are the
Allegation, my lord. The Brundavana suburb, the present informant, lodged this affair that some bank has sent to them that repayment of a loan amount. They have saying that they have not taken loan from the bank. Why notice has come? They have also mailed second para. They have categorical informant stated. प्रकाश था कि ऋण परिषद नोटिस पाइबा किछि वर्ष पूर्वे दिस पर्टिकुलर मेथड मतलब माछमरा दायर सर्कुलर पियन आरआई पियन जगन्नाथ भूइया प्रेजेंट पिटिशनर दैट केस आल्सो मेलड फेयर लिखा है आम गाँ को आसी जंगल जमी पट्टा निया जीवो बोली करी आम गाँर केतेक लोकंक ठारू जमी पट्टा भोटर परिचय नैथिले दिस जगन्नाथ भूइया
the annexure 2 which you have filed?
annexure 2 that is the charge sheet milord
Charge sheet you have not filed. This is not complete charge sheet. What have you filed?
charge sheet filed by the offense under civil can have a glance
Yeah, the only one page you have filed.
no mu 4-5 page milord
Where is the brief facts?
milord the brief facts milord that is
In charge sheet.
charge sheet milord
Where is that?
no
Where is the narration of facts in charge sheet?
milord mo rahi hai milord sorry milord for that
The inconvenient paper you have taken out.
no not
Which is
taken out
inconvenient?
more achi milord not taken out
I am searching that only.
that milord sorry milord kind of
It is same allegation, but facts remain. The accused person is acquitted in other case, and except 2 is my reliance annexed. That is the informant is different.
only
But here is a case, my reliance is
What are the allegations you
allegation
take?
is that present person is working as a PO in the RI office and come to the house of the present informant and collected the photo parichaya patra, photo and Aadhaar card in order to give the jungle land, forest land in favor of him. Thereafter, by using that documents and obtain the loan from the State Bank of India and thereafter after issuing the notice for recovery to the present complainant or informant, thereafter the informant came to know that by the said PONO and bank staffs of the RI office is by manipulating said document.
You have done the same thing with someone else.
Yes.
You faced the trial, you got acquitted. Now you have done with this.
no same allegation milord same
Allegation may be same. The conduct is also same. Your conduct is also same.
else everything is same milord
Murder, suppose. Then once I committed murder to X, so therefore I can murder anyone else.
same allegation faith that arrested
But informants are different.
informant
Their lines are being grabbed.
Mala there are so many one after another one there are
What can I do?
you will kind have a glance annexure 3 milord
I have seen it.
that is judgment milord judgment prosecution case mala similar
That's the reason you have not filed this.
no milord
paper.
reason milord saman milord setire jaha story
The
etire
reason may be same.
Offense saman.
See, in 2 different points in time, you have committed 2 crimes.
no 2 crimes sir 1 crime milord therefore my lord think that is my friend is not my lord some placing my lord
Just see.
my lord what briefta delivery
You have taken the documents from X, documents from 1.
annexure 3 ta lordship can't have a glance order of acquittal setire सब जिनस लिखा है jaha
This
present
is vis-a-vis another informant
informant ta khali
whose land you attempted to grab by manipulating documents and all.
Khali-
You got acquitted. It's all right. But the same thing you have done with another guy.
No, same allegation FIR what
Informant, you show me the informant. in
My
this
lord,
case.
informant. That is the present FIR, my lord.
Case 9 Vrindavan Savan is the informant.
Hmm.
That my
That
lord
can-
is short for the question.
Brindavan Savar.
Vrindavan. But in
Brindavan Savar.
acute
He is a driver.
case, in acute case,
Sir. That is here, my lord, Brindavan is the informant. Allegation is the similar. But I got present petition.
How many times you will repeat? I can't, I understand this much.
My lord, here, my lord, in the FIR, he has categorical stated.
I understood that also.
Mo kotha koile.
Hence, the rest of the thing you tell.
My
Whatever you
lord,
are.
thereafter the control annex 3, my lord.
Yes.
My lord, the kind of glass the prosecution story, offense, everything is saman. Page 17, my lord. Offense as a 420, 467, 468, 471, 120B, 409.
Your modus operandi in commission of the offences are same.
Same.
For two people.
আর 2013 মধ্যে ସେଥିରେ FIR আমার মধ্যে 2013 allegation
You argue all these things at this.
2013 allegation ସମାନ ତାଙ୍କର 13 ଆମର ଏକଥା ବି 13 ଲେଖା ହେଇଛି
Petition is agreed by the order dated 10/2/2017. Cognizance is taken 2017. Now you are coming. What is this is?
ମାଲେ ଟ୍ରାଏଲ ଚାଲୁଛି ମିଲଟ
And then?
I'll supply my other evidence copy mill
No, I can't do that. Right now. Whereby the learned SDJM Paralakimundi has taken cognizance of offences punishable under section 420, 468, 471, 409, and 120B, 34 IPC. IPC. After the cognizance order was passed by the court below, charges have been framed and against the petitioner, and the trial is proceeding. At this stage, the petitioner has approached this court seeking quashing of the cognizance order on the ground that on the same ground he was subjected to prosecution by another complainant. Another complaint in GR case number 335 of 2013. The JMFC Gajapati Paralakimundi
same court
wide its judgment dated 5/4/2019 has recorded an acquittal in favor of the petitioner. Relying upon the said judgment of acquittal, he submits that on the same ground, the present complaint is prosecuting him in the instant case. Since the trial is at an advanced stage and the impugn order has been passed in 2017, I am not inclined to entertain this petition. However, liberty is granted to the petitioner to raise all these points which have been raised in this present petition before the trial court at the appropriate stage. If such issues are raised before the court below, the same shall be considered by the court below on its own merit. With this observation, the petition is disposed of. Yes, next.
18.
The petitioner is a newspaper agency lodger. And petitioner number 2 is the reporter. The brief facts is that in 2021, 2/4/2021, a lady had lodged an FIR lodge. Basing upon that, a publication was made against opposite part number 4.
Yes.
Subsequently, that lady has changed the implication of opposite part number 4 by filing an affidavit. Accordingly, that publication was also printed lodged. Third stage, that lady met a compromise with the opposite part number 4, wherein all we have it was also published that there was a compromise. The opposite part number 4 files a legal notice against the petitioners saying that defamation has been made against. We have made a reply, the petitioners made a reply that we have acted upon an FIR. So, and as and when the version of the lady changes, we have also reflected in the now he has filed a complaint case.
Projection of true and
Yes.
right facts.
Right facts. Basing upon the records, we have he files opposite part number 4 has filed a 160 case. At page, if your lordship says page 39, that's the impugn order, your lordship. Wherein the learned magistrate had, if your lordship sees, 39.
39 is Vakalatnama. Your Vakalatnama is there. 39. There is no 39.
I'll let it come tomorrow. I'll.
Annexure, which annexure you are talking?
Annexure 8, your lordship, it's a continuation.
Annexure 8 is the complaint case.
Yes. After that, page 30.
After that, you have not filed in.
Sir, I'll.
I think you have missed that.
I missed that.
MP order.
Let it come day after tomorrow.
What do you want?
No, basically what has happened, the magistrate has issued notice under 156 to the police for investigation. Now that was kept silent. In 2024, police registered a case against me.
For 500.
Under 500. My whole submission is that Honorable Supreme Court has categorically stated in 499 and 500, no FIR can be lodged, nor 156.3 can be, by magistrate cannot indulge into 156.3.
Yes.
He has to always prove 200 and 202 years. That is the Honorable Supreme Court's order. So against that I have come to.
The another point you have not urged, there is no affidavit filed by the informant against you in the complaint.
In the complaint. That I have.
You are covered by the Priyanka Srivastava.
Yes, that I have not.
That you have not, neither you have pleaded, nor you have filed that. That's one of the
yes, that's
most important point in your favor. Priyanka Srivastava.
If 156.3 goes, then
That's right,
yes,
but
yes, I'm obliged.
So if it is 200 petition also,
yes,
for that you need to have an affidavit.
Yes, yes.
Because it's a 500 case,
yes,
unless and when the allegation just see the allegation
it goes back to the threshold.
Yes. So then everything falls.
Yes.
I'll take it up next week. You file those documents.
I'll do it in the course of the day also.
I'll take it up then since there is no, the impugn order is not there in the file.
Yes.
What can I do?
No, that is
I would have issued notice.
So let it come next week, your lordship.
Next week. Tuesday. File it.
Great.
And take that Priyanka Srivastava also.
I'm sorry, there is some clarity.
No problem. Why don't you settle it out? You are the newspaper. I'll just pass an order that in the prominent
let notice
in the prominent place of your newspaper you will
I have changed.
send an apology.
I have changed as per the version of the victim. I have changed as per the victim. So it is not that I have made something out of money. There is no enmity.
What is happening to their marriage?
No, there is no marriage.
No, that is going on. Their problem is going on.
That has already resolved.
That is resolved.
Yes.
Then doing nothing. Yes. I'll just come. 1 minute. Yes. The compromise matter. Yes. Yes. Cross cases, huh?
Yes, my lord. All the present, my lord.
Last submitted on the 294, 323, 341, 530.
Madan Mohan.
31 SC state.
Diragare Satri likh do.
Yes.
Diragare Satri.
Joint update देना है तो लिखी जो थी पारा page 8 पारा 8 रो lecture.
There is no affidavit.
There is not.
Affidavit is
Two cases, my lord.
Huh?
Two cases. The both two persons filed.
Page 8 D रो lecture they decide to keep harmony between
since both the petitions are arising out of the cross cases being filed by the parties against each other by the common order and the present petition in the first case, that is 36110. So next the instance of opposite party, the FIR is no number so registered and the allegation of the petitioner. Next array, the 4345 again, that instance of both the cases mentioned above, referred to above, are cross cases rising out of same investigation is over.
Yes, sir.
After the investigation, charge sheets in both the cases have been filed for alleged commission of offences punishable under section 341, 294, 323, 506, 379, 34 IPC, reading section 31 R and 31 S and 32 VA. When
379 is not there.
379 is not there.
charge sheet
Phase 9.
Charge sheet is not that 379. Guys, you don't file anything. Everything I have to believe. Where is that? And second petition, where is that?
Second petition file kora. First petition bro.
I am referring to second petition.
Second day before yesterday I married.
In the second petition, what is the charge sheet? What are the difference between the charge sheet in both the cases?
Nothing married.
Same.
Same method, same allegation, same.
Same, not same FIR.
Same FIR.
Why are you saying same FIR always?
Yes.
Why same? Yes, 379 control. Okay. Charge sheet in both the cases, charge sheet filed on the same day.
Yes, yes.
Charge sheet is filed on the same day in both the cases on 31/3/2021 for alleged commission of offences. So on. When the matter was set for trial, the parties have settled the dispute and have filed the aforementioned two petitions for quashing of the criminal prosecution initiated by them against each other. The petitioner in both the cases and the opposite parties are present in person today in the court, being represented by their respective counsel and identified by them. The parties have not, although not the parties have not filed the joint affidavit, regarding their settlement term, because both the parties have filed separate petitions seeking quashing of the FIR, quashing of the FIR on the same ground. Regarding to the fact that the parties have settled the dispute in both the cases and decided not to proceed against each other. I'm of
D टा put कर दलो.
नहीं
Page 8 रो D टा put कर दलो होगा.
8
Page 8 रो.
Page 8 paragraph D. Which petition? First one.
First one. First, second also they mentioned. D ground D.
And the parties have D for Delhi.
Yes, madam.
For that both
And the parties have both the parties have settled this matter. The parties have specifically mentioned in both the petitions as under D. I'm of the considered view that subjecting the petitions in either case to the rigors of the trial is destined to be right? Hence, they are covered by the case of Jan Singh and so yes. Yes.
Item 19.
The present petition filed this application challenging the order of cognizance as well as entire criminal proceeding on the ground of civil dispute. Fact is, in December 2007, complainant alleged that present petitioner went to his construction site where he has constructed his boundary wall, did not allow to construct his boundary and threatened her. My submission, after 1 year, he has lost the affair. Prior to that, I have filed a criminal civil suit, status quo is there, In spite of that, he is trying to construct the boundary wall in the disputed site, Subsequent what, after 1 year, he has lost the affair. Kindly have you glanced to, page 48 Miller.
What is the stage?
Stage Cognizance has been taken Miller, page 48, kindly class, page 48 Miller.
48, yes.
Enter 12 person are there Miller. 9 are ladies Miller, only 3 person are the gents Miller. Allegation against the 3 person Miller, kindly page 48 Miller. Statement of the informant.
Yes.
ମୁଁ ନସିବା ଖାତୁନ ସ୍ୱାମୀ ସାଂସ ମୁନ୍ନାଙ୍କ ପରିବାର କୋର୍ଟରେ ଜମି ଜମା କେସ୍ ଚାଲିଛି କେସ୍ ଫାଇଲ ବାଇ ଅସ୍ ମିଲର ଗତ 28/12/17 ଦିନ ସେଇ ଜାଗା ଉପରେ ମୁଁ ମୂଲିଆ ଲଗେଇ ଘର କାମ ସମୟରେ ଅଲ୍ ଲେଡିସ୍ ମିଲର
When the FIR was registered?
FIR registered ମିଲର 13/12/18 ମିଲର
13/12/18 28/12/17
এটা হচ্ছে অকরান্স মিলর সে লেখিଛନ୍ତି 28/17 অকরান্স মিলর 13/18 FIR মিলর ইত্যাদি আসলে ঘর তিয়ারি কাম করতে লেবর মানকু মারিଥିଲେ ঘর তিয়ারি জিনিস ভঙ্গাভঙ্গি করছে
is notice to opposite party number 2. No, petitioner is seeking the passing of the order dated 27/12/2019 passed by Lebanon JMFC 1 Bhadrak
Miller
in GR case number 2018 of 2018. 2018. Whereby the cognizance of offenses punishable under section. Where is that cognizance order?
Annexure 1 page 19 is
punishable under section
341, 343, 394, 354B, 509, 506, 34 IPC.
So against the petitioner. Petitioner submits that the incident there are civil suit pending interest a party. The petitioner, the opposite party number 2, na? Opposite party number 2. Opposite party number 2 has registered the present FIR on 13/12/2018 pertaining to an incident which has happened, allegedly happened on 27 this is a dispute arising out of primarily civil. This is a civil dispute primarily this is a civil dispute, and the opposite party number 2 is trying to paint it to a criminal one, and has filed the FIR after lapse of
1 year.
About 1 year. Issue notice to opposite party number 2, returnable so and so. In the meantime, proceeding before so and so will stay. Yes. Yes.
20 Miller, on the basis of compromise between the victims, the present case has been filed for quashing of the proceeding, and so annexure 2 is the settlement measure. Filed affidavit before the court below. So date may be fixed after vacation.
376.
That FIR is
also there.
FIR measure on basis of telephonic the FIR has been lodged.
No. Whether in these kind of cases they get compensation for registration.
Because here Rossi may see the allegation.
Had she received any compensation?
Nothing. No compensation. He has got married to somebody else, my lord, and thereafter lost the affair on basis of
that she is supposed to be a
scheduled caste, my lord.
Scheduled caste.
That is because the sole fair, my lord, Rossi may kindly have a glance.
Yes.
That after she got married to some other person, thereafter she alleged that on telephonic she threatened me that I have relation with you, I will disclose. That is the allegation. Now matter has been settled, my lord. Since last 7 years they have love affair, everything she admitted.
And you have retained some photograph.
That is their allegation. Nothing. Nobody.
After investigation, this has come, it seems.
Yes.
Yes.
Page 15
60 and 67 of IT Act also is there.
Because of the allegation, it has been alleged. Nothing has been come in the investigation that he has shown to somebody else and nothing, man. So already annexure 2, there is affidavit before the court below, for which I pray, Lordship, unnecessary the hostage of court time, because nothing will be happened, and your Lordship judgment is also there. That is, I pray, my lord.
You are threatening to her
That is
husband,
allegation.
her husband and threatening
That is she alleged that after page 15, plus she may see annexed 2, she has given affidavit that matter has been settled out of.
I'll just issue notice, let us bring it.
Yes, ma'am.
And in the affidavit, you say nothing. Just see the affidavit.
Page 15, your lordship, before the oriental.
No, compromise affidavit.
The compromise affidavit not there, your lordship. Only affidavit.
Settle the matter outside the court, that is paragraph 1 last name.
I think that affidavit is for the concern of bail before the trial court.
That is why notice your lordship is taking notice. I don't have objection.
I'll just issue notice, let us see.
And
This affidavit is not satisfied.
all right, my lord.
This affidavit is only.
You want mail, that much is enough.
Lordship notice may be issued. And I pray may I file adjournment petition
You move application.
that
Yes.
may be there.
Okay, 20.
21.
As an interim, I pray
Yes,
that I'll file.
yes.
All right, ma'am.
Yes, 21 withdraw. Withdraw, yes. 22.
It's a compromise matter, Your Lordship. Can you pass over? The parties are here in the court, the affidavit.
What are the offenses?
Your Lordship, 294, 323, 325.
323.
Yes,
Charge sheet isn't filed? Cognizance is taken.
Yes, Your Lordship.
What are the offenses? Cognizance?
What happened, one more submission, your lordship, out of, with, accused number in 5, your lordship, but 2 has approached before for quashing, your lordship. Here is total number of accused is 5 number,
Yes.
but
2 have approached.
These are come to
Why?
the honorable court for quashing.
Lordship, the victim informant has in the meanwhile died. Father and son. The father was the informant, alleging that allegations. So the victim was the son. The son is before Your Lordship today. He will be there in.
No. Why has he chosen to settle the dispute?
Out of 10.
There are many accused. He can't
Lordship.
choose it.
Yes, Your Lordship. That is the.
He can't choose it. Either you settle the dispute.
Yes, Your Lordship. So kindly, Your Lordship, the matter be passed over.
No. Only 2 persons have come
Yes, Your Lordship. The victim
saying
is
that
not-
we have settled the dispute.
yes, sir. And also the victim is saying he will not quash against the petitioner number 1, but he's agreeing to quash against petitioner.
No. He can't choose it. He's
Yes,
not. He must be collecting money from all the accused persons. Whoever is paying, he's giving consent. This is not. This court will not allow him to collect money from 10. You made 10 accused. 2 of them have filed the petition for quashing. You say that I am agreeable to.
This is the victim, Your Lordship.
Victim may say whatever.
Victim is the one who is saying this, Your Lordship.
These are the offences against state. I pass it over. I
Yes, Your Lordship.
dismiss it. We
Pass it over, my senior will Your Lordship.
dismiss. You can't choose it like
Yes,
this.
sir. All blessed.
23.
May it please, Your Lordship. Item number 23, my lord. Lordship, a tribal civil dispute between the party is converted into a criminal case, Your Lordship. Initially, my lord, the present petitioner lodged a complaint under the offences of IPC, including 341, 294, 506, and other provisions of the SC and ST Prevention of Atrocity Act.
Where is the affair?
Starts from page number 15, my lord. Before going to the prosecution case, my lord, I want to bring your lordship's kind consideration about the complainant's conduct and the civil proceedings.
On the basis of complainant conduct, the affair can't be quashed.
Your lordship, that is a different part, my lord. But what happened in this matter? Your lordship may kindly turn to page number 35.
30?
35, my lord.
Yes.
The dispute is going on since 2005.
There is a suit pending.
My lord, 35 is another charge sheet part, my lord. Initially, the complainant side lodged a case against the petitioner side, my lord. The finding of the police investigation.
And Abhay Mahapatro.
35, page number 35, the charge sheet page, my lord.
Abhay Mahapatro, Vijay Mahapatro.
May I read, your lordship?
Jilly Malik. Yes. 35, yes.
May I read, your lordship?
35 where?
Sec B, Monchi Parag.
35 is the suit.
Civil suit.
Civil suit.
34 may kindly, your lordship.
34. You are reading FIR?
My lord, the charge sheet part, your lordship.
They have lost previous affair. That charge sheet part, my learned friend wants to start.
Which
It
page
starts
you are
from
talking about?
33 to
33, my lord.
This is charge sheet.
My lord.
Okay.
Your lordship.
Previously,
During course of investigation.
34, page 34 you are reading. Yes.
My lord.
Yes.
During course of investigation, I visited the spot, examined complainant and witnesses, seized some bamboo plant
So,
and
yes.
half burned polythene, this and this.
All the-
The villages of Paradip Gad have also arranged several meetings between them for amicable settlement.
This is the charge sheet arising out, this is the charge sheet which you have.
No, that is a different first case. There was a first case, Your Lordship.
The previous occasion.
The complainant side lodged a first case against the petitioner side, my lord.
Side, what side? Who is the complainant here?
My lord.
He is Gopal Malik.
My lord.
ठीक है?
Golab Malik.
Golab Malik,
My lord.
wife of Manmohan Malik.
My lord.
He is the complainant.
Complainant in this case.
And who is accused in this case?
The present petitioners and other relative of
Where is that?
He is the Jilli Malik.
No,
He is the Jilli Malik.
Your Lordship, page number 29.
Accused.
29. Abhay Mahapatra, Manoj Mahapatra, Bijay Mahapatra.
29.
My lord.
This is Gulab, yes.
Abhay Mahapatra and Bijay Mahapatra is the present
Yes.
petitioner here.
And after investigation, the police says that they are in habit of filing
Criminal cases.
Okay, it's all right.
Because, my lord.
That is Gulab.
A piece of land, that is the first one. A piece of land belongs to our the present petitioner, Your Lordship.
Who is Ghasiram?
Ghasiram is, my lord, Ghanshyam is a
Ghanshyam.
relative of the complainant.
What relative?
Relative means uncle.
There are three persons now. Gulab,
My lord, they are,
Dilli,
my lord,
and Ghanshyam.
entire, Your Lordship,
Gulab has first filed a case against you,
my lord.
where the investigation has taken place. The courts, the police says that they are habit of filing the
The
case.
complainant and family,
Family member.
my lord.
And how will you establish Ghanshyam? Who is Ghanshyam?
Ghanshyam
And
is
who
uncle.
is Dilli? Who is Gulab?
My lord, 8 is to 8, Your Lordship. 8 versus 8. The case is going on.
Because only title Malik.
No, my lord. They are relative, Your Lordship.
What are the, see,
Your Lordship,
Ghanshyam Malik, who has filed a suit against you,
my lord.
is the son of late Sapani Malik.
My lord, I will
Okay.
I will prepare a chart, Your Lordship, for my lord's I will
Where
prepare
is
a chart.
Malik title is there, you are taking
No, my lord. They are relative, Your Lordship. I will prepare a chart.
Mahapatra family and Malik family.
That is
Yes.
different. There is no difference.
The Malik family belongs to Sibo Sankar.
What are the allegation in the FIR which you are seeking quashing?
They are saying no, we abuse, my lord, in a filthy language. That is only allegation. We abuse in a filthy.
And how many
Lordship,
cases
can you
are there against each other?
This is the only case, my lord.
And a civil suit is pending.
My lord, civil suit. Different
civil
type of
suits.
civil suits.
2 civil suits, 1 revenue case, and
144 proceeding.
144 proceeding.
I'll issue notice,
Yes.
bring them, send it to mediation and
My lord.
let us finish all the matters.
The matters, the dispute going since 2005.
Call them who
Well,
are facing.
gratefully.
Issue notice to opposite party number 2 and give the list of cases pending
My lord, I will prepare a chart.
and give it, and all the cases I'll refer to mediation.
My lord, gratefully.
Okay. Mr. Sahu, learned counsel for the petitioner submits that there are as many as how many cases you said?
2 civil suits
There are as
of
many,
different Malik family
Yes,
and
yes.
Mahapatra.
2 civil suit, 1
44 proceeding,
144 proceeding and 1 revenue case.
as many as 5 cases pending against each other.
Yes.
Civil and criminal.
Including civil and criminal case. It appears that there is the dispute is among 2 families, namely the petitioner's family and the family of Jilli Malik, the informant. Malik is the informant. All the disputes are arising out of a misunderstanding, arising out of a misunderstanding, arising out of a land dispute, arising out of a land dispute. Issue notice to opposite party number 2, returnable to so and so. In the meantime, where is the proceeding pending?
The proceeding is pending, my lord. Additional district and session judge Pujan.
Special.
Pay करके बस आप ऊपर लिखो. Mr. Sahu, counsel for the petitioner also submits that since the interstate dispute in the parties are arising out of land dispute, there is a scope of settlement. between both the families, family. तापर issue notice करें, ठीक है. And
24.
bring them, I'll send it to mediation of, give the list of the cases, all the cases will be referred to mediation. Yes. Yes.
24.
24, my lord, I am watching. Here, your lordship, I prefer one application under 311 of the CRPC. Because, my lord, for the petitioner accused, one previous counsel is appearing, my lord. At that time, two witnesses are examined, PW1 and 2. At that time, your lordship, the two witnesses declined, my lord. Cross-examination totally declined, my lord.
Where is that?
The page number, my lord, 28 is the PW1 and page number 30 is the PW2. Totally cross-examination ही नहीं है.
Where is the impugn order?
Impugn order is
Page
at
16, my
page
lord,
number
relevant
15.
portion.
15 and 16.
What is the reasoning?
Reason, my lord, because the present petitioner preferred one bail application before this honorable court, and this honorable court targeted the matter to conclude the trial within a stipulated period.
You are trying to prolong it.
Well,
where is that order?
My lord, page number 15 and 16, order dated 20.
No, where is the High Court order?
Yes, yes. High Court.
Where is the High Court order? By which targeted?
My lord, your lordship may kindly turn to page number 23. 23.
Okay. Here. This is the order dated 11/9/2024. Now, where is the target?
Your lordship?
Rejection of what is the bail restriction removed and also bail and Patna and the rejection of the where is the target?
Targeted, as trial is on verge of completion. Page number 25, I am reading, my lord. Trial is on the verge of completion. I am not in.
End of November 2024.
Yes, sir.
That is over.
That is over, my lord. In the meantime, the present petition.
Trial might have been over now.
My lord, what happened in this matter?
Trial is still going on.
Still going on, your lord.
Despite the order to complete it November 2024.
My lord.
Your lordship, we kindly page 16, the last paragraph.
16.
Peruse the case record and other documents in this record case. This case also, on perusal, it is found that PW1-2 have been examined on 7/3/2024 and the closure of the evidence from the side of a prosecution. The Law and Defense Council filed 231-2 CRPC for defer the cross-examination P and P2, which was rejected by the additional session judge Bhavan Patna on 13/6/2024 on the present petition of the accused. Present conducting counsel have filed vakalatnama, but present defense counsel has not filed any petition after
examination
in chief to recall the witness PWP of their cross-examination. After 9 adjournments.
What are the offences?
NDPS, man.
NDPS 715.
But therefore, he is entitled because both the witnesses have never been examined, cross-examined. Completely declined. And in 2024, what is the date of examination?
7 March 2024.
And he is in custody.
My lord.
You want to delay? Let him delay.
7 March.
Despite this court has targeted,
yes,
he wants to delay. Let him delay. Be there in the jail. What to do? I'll allow one opportunity. Same order.
My lord, your lordship,
one opportunity. So petition rejected by the order dated. Order dated
28/11/2024.
Passed by the special judge Bhavani Patna in 2ACC case number 18 of 2023 bracket NDPS, whereby his application under section 311 CRPC for recalling PW1 and 2 has been turned down. The trial court has turned down the application primarily on the ground that the present petitioner had approached this court by filing a BLAPL number 7996 of 2024. This court by order dated 27/9/2024 rejected the bail application. However, targeted the trial to be completed by end of November 2024. Mr. Rahul and counsel for the petitioner submits that the trial has not yet been concluded. The petitioner is still in the custody, and he submits that since the petitioner is facing serious charges of NDPS, he has the indefensible right to cross-examine the witnesses, to whom he has not at all cross-examined. I have perused the evidence of PW 1-2 recorded on 7th March 2024.
Your Lordship may kindly
2024. The defense counsel has declined to cross-examine the said witnesses. Regarding that to the aforementioned, I am of the considered view that the petitioner is entitled to at least one opportunity to cross-examine the said two witnesses. Accordingly, the trial court is directed to fix a particular date and summon these two witnesses. We summon PW 1 and 2 and afford an opportunity to the petitioner to cross-examine the said witness. It is made clear that the trial court shall complete the cross-examination of both the witnesses on the same day to be fixed by it, and the defense shall not be allowed to seek adjournment on any ground whatsoever. On any ground. What do you want to do?
My lord, I'm relaying this case now.
What do you do? Since the plan has already targeted the trial to be completed by November 2024. However, the reasons not forthcoming on the court, the trial has not completed the therefore, the member will also that yes, sir. On 9 December 2013 NDPS was issued. 2013. These are part of the refinement of around 59. Whatever 2013 yes, ma'am. 15. The same 1500. Another figure. The same 1500. Same situation. How many cases are there? Well, this is 115, 16, and 17. Same yes. Oh, I got to the
This is on 18/12/2023. Yes. 18/12/2023. Yes. And 7 years of the paragraph 3 and 4. It has been mentioned. I know where.
Petitioner number one was made on 19/9/2027 and petitioner was 16/8/2019. 500. BCD from that we will miss it and taking on continent and 2024. By no user on three other when it update the user permission and then read the start of the 580. We will write it. How do you know?
May I please your lordship, item number 30.
Yes, 33. Yes, yes. Yes, 33. Yes. 33.
Item number 30, my lord.
34. Please, your lordship. And therefore, when on 37/2018, my lord, and the loan was issued on 20/12/2022. 22/1. Yes. Yes, madam. Seven 9/2020. Yes, and NDPS is 31/5/2021. Subsequently, when I came to the light that this is having relation with the wife of the present person. The wife was also granted the property in law. Subsequently, when what happened, there is no else only they are conscious. Wife has been granted there. So, but the conscious will consider have annexed and given the document as well as also direction. After that, I will be extra to have wife in the body there. Going there, this is having relation with the present. Also granted their body. This is wife of the present person. You have eliminated. So that's the allegation manner, only confession before the police. While if they are in illegal custody manner, confess that. This is how the relation with the petition of the wife of the second petition. And the quarrel between wife and husband, wherever they are planned to see the missing forest, I have another exception, I have given the exception matter to one. Recovery exception matter. The, let's say the recovery exception of one. Let's last one. And that's, again, I will come, constitutional, constitutional.
Yes.
So, may I give the statement? Are you indicated that you are going to move on another quality way? You might come and see us somewhere. You might come and have you for a thing, you are considered a career, this is equal to love you. However, for a senior, doctor. Let
Eight witness examined. Eight witness examined out of the 17. And that is the direct evidence which evidence and so many evidence. Witnesses support to proceedings. All the eight witnesses. That's what I'm asking. All the eight witnesses they turn like. Hey, yes. Yes, yes.
May I please, my lord, item number 40.
Yes, yes.
My lord, this is a case under section 20B2C, and this is a successive bail application of the accused petitioner. Your Honor, the allegation against the accused petitioner is that he was found in possession of 143 kg of ganja, my lord. And my lord, he is in custody for more than 400 days, and that is from 2nd November 2023, my lord. My lord, 2nd November 2023, my lord. My lord, in the meanwhile, charge sheet has been submitted, and PW witnesses have also been examined, my lord. My lord, this is a fit case in which the dictum of Avtar Singh applies, my lord. My lord, in this case, the petitioner are only the laborer, only the traveler of the auto rickshaw from which the so-called seized ganja is recovered, my lord. Apart from this, there is no allegation against the petitioner. Only their presence is proved, my lord. Apart from that, there is no single piece of evidence against them. In this case. Pardon, my lord. My lord is not.
Recovery.
My lord, the recovery is from an auto rickshaw, my lord, and the driver of the auto rickshaw fled away from the spot, and these two petitioners were only sitting in that auto rickshaw, my lord. My lord, 4 number of witnesses have already been examined, and I have annexed the deposition of PW1, my lord, wherein he had stated a completely different version regarding the description of the ganja, my lord. My lord, at page number 36, I have annexed. My lord, PW1 has already been examined, my lord. After and thereafter, the bail has been rejected, my lord. Extremely sorry, my lord. Extremely sorry, my lord, but the my lord is not audible. My lord, may I pray for a Passover? My lord is not audible at all.
Yes.
By the prosecution, Lordship. The relevant party is page 9, Lordship. It's not a fact that I have stated before the police that there was frequent call between the accused and his wife, and that the accused used to assault her at the time of divorce demand bullet motorcycle from her parents. And 14/4 in the morning, there was a quarrel and fighting in between the accused and his wife, and the accused had gone outside on that day to bring milk on 6 p.m. When he returned to home, he saw his wife Suman has committed suicide by hanging in the can by means of a chunni, and that he took her to the hospital by means of
after the charge sheet was filed, the petitioner was put to trial. There are as many as 8 witnesses have already been examined by the prosecution. All these 7 witnesses, right? All these witnesses. What is the name of the accused?
PW4 is Rabita Devi.
Name of the accused?
Accused Sunita. Accused Lordship the Raju Jadhav, and the deceased is Sunita Kumari.
7 witnesses have been taken. It is all the 7 witnesses, those who are independent witnesses, cited by the prosecution, being the post-occurrence witnesses and post-occurrence witnesses have resigned from the earlier statement given to the police under section 151 of the CRPC. The charges against the petitioner is for commission of legal offence under section 498A. charge sheet is 304B.
304
and 306.
306 498.
498A, 34 IPC review section 4 of you are the judgment, huh? You are the only accused?
Only accused. The other accused are there, Lordship. Others are there.
Where is the charge sheet?
Charge sheet, Lordship, I have given flag C, Lordship.
How many accused are there?
Out of the 18 charge sheet, examined.
That's okay.
38.
How many accused persons are there?
One, Lordship. I'm sorry, Lordship.
What kind of preparation you people have? How many accused you don't know? When charge sheet is filed, you don't know. I'm asking something you are not able to answer. Both the sides are same. For bail application, it would take half an hour. The charge sheet has been filed on 14/8/2020. Okay. Out of 18 witnesses cited by the prosecution, 7 witnesses have been examined. 7 witnesses have been examined, and they are the post-occurrence and occurrence witnesses, and cited by the prosecution is an independent. None of them has supported the prosecution. The petitioner is in custody since 17/4/2023. Regarding it to period of custody and the nature of litigation, granting bail. Yes. Opposite party.
Opposite party, Lordship, he is there. He has appeared. His lawyer has also appeared, and he is also personally appearing. 64.
64. Yes.
My lord.
This is Surwawala Sahu. Huh?
So, her son is there. She is bedridden. She's 73 years old. She is suffering from heart ailment. So,
Lakshmi Builders, who is
Lakshmi Builder.
Please come forward. Huh? Please come.
Yes, Govind Patel. Yes.
Govind Kumar Patel.
Yes, yes, he is there. Okay. His lawyer is also there.
You are agreeable to that? Okay.
Item 70.
You have come against that 20%.
Yes.
20%.
Yes. Your Lordship, this judgment also. My Lord said that the Honorable Court can exercise discretion. He is 73 years old, suffering from heart ailment. And moreover, principal accused is dead. Her husband is dead, who has issued the check. But Your Lordship, finally, it could be settled. 17 lakhs check, 27 was ordered, 6 lakhs we have already paid, 20 lakhs we are paying.
This judgment I was talking about. Just
My
Lord. But they said that you have to pay.
That is, they are insisting to pay. So, Your Lordship may quash the conviction and they complained.
What is the check amount?
17 lakhs.
And 20 you are paying.
27 was ordered, 6 lakhs already paid. 20 now we are paying.
Yes, sir.
Joint affidavit says.
Let me dictate the order first. Huh? At the instance of opposite party and principal accused was your
Dead.
Husband
of Surwawala Sahu.
He was also one of the accused.
He has in fact issued the check. I am the joint account holder.
Okay, right. At the instance of opposite party number 2, the 1cc case number 3997 of 2012 was initiated against the present petitioner and her husband for alleged designer of course check amount of 70 lakhs. 70 lakhs. The petitioner and yes, the petitioner who was the joint account holder along with her husband had allegedly issued the check. When he died after the conviction?
No, my lord. During pendency of the case.
During the pendency of the trial, the husband of the present petitioner has expired. So therefore, the petitioner faced the trial. Eventually, by the judgment dated 24/10/2019, the learned JMFC first class Bhubaneswar had recorded a conviction against the petitioner, petitioner and passed the following order. Page 24, last order. Page 24, last order paragraph. Against the order of against the judgment of conviction and order of sentence, petitioner filed where is the appeal? Petitioner filed criminal appeal number 79 of 2019 before the additional sessions of the commission. While admitting the appeal, the petitioner has been directed to make 20. What was the order?
That is Annex
20% of compensation.
Page 36.
Compensation amount is a precondition for hearing of the appeal. The petitioner is agreed by the said order and hence approves the court for setting aside of the said interim order passed by the appellate court. Now, when the matter stood thus, the parties have arrived at a settlement. As per the settlement, the petitioner had agreed to make good how much? 20, total 20.
20 lakhs. Now I am paying 20 lakhs.
And 6 already paid.
Already paid. That I will annexed also.
Petitioner has agreed to pay 20 lakh rupees to the opposite party over and above 6 lakhs rupees, which has already been paid, deposited, already been paid. The opposite party has also agreed to the said terms. The petitioner is a 72-year-old lady, therefore he is not present in the court. However, her sons are present in the court and representing her. She is also represented by Sir Thompson. The opposite party number 2, namely the director of Messrs. Lakshmi Builders and Development Private Limited, Mr. Govind Kumar Patel is also present in the court and being represented by his lawyer. As he has, both of them have agreed to the terms of settlement. On the basis of the settlement, the prayer that the entire dispute can be put to inquiries. A joint affidavit dated 6/12/2024 has also been placed on record, and in trail we are stating as under the Parafour 1 2 3 Parafour 1 2 3 Parafour Purada. On the next one, on the basis of this settlement, the petitioners are seeking indulgence of this court for quashing of the entire criminal prosecution. The appeal is pending before the Court of Sessions against the conviction and sentence awarded by the court below, awarded by the trial court. Mr. Mishra and the counsel for the petition has now relied upon the judgment of the Honorable Supreme Court passed in criminal appeal number 964-966 of 2010, Damodar S. Prabhu versus Syed Babalal X. Relying upon the state judgment, Mr. Mishra says that even the appeal which is pending would be disposed of on the basis of the settlement terms. Settlement. In the perusal of this judgment, it indicates that the Honorable Supreme Court has indeed laid down the law that at any stage the case arising out of a complaint under Section 138 NI could be put to rest on the settlement terms. However, if the settlement takes place at the trial stage, 10% of the check amount is liable to be paid additionally. And if the settlement takes place at the appellate stage, 15%, 20%, 15%, and subsequently 20% of the check amount is also directed to be paid. But there is a rider to the said condition. If the parties have agreed to accept the whatever settlement amount, it is not necessary to impose such condition. In the instant case, both the parties have agreed to the settlement. The check amount is about 17 lakhs, whereas the petitioner accused has paid 26 lakhs. 26 lakhs in total. 26 lakhs.
26 lakhs.
26 lakhs in total. Therefore, even the condition laid down by the Honorable Supreme Court in Damodar S. Prabhu Supra is satisfied in the present case. Satisfied in that view of the matter, the conviction and sentence order dated 24/10/2019 passed by the JMFC, Bhubaneswar, in ICC case number 3997 of 2012 is satisfied on the basis of the settlement. Allowed.
Accordingly, the appeal has become infructuous.
Appeal has become infructuous. The appeal has become infructuous.
Obliged.
My lord, sorry to interrupt, my lord.
Yes.
My lord, I'm sorry to interrupt. Item 70, let's remember 3 p.m. This is ABB students in council met issue. Let's fixed to 3 p.m. but it was noting is not there. So
which item?
Taken up this item 70. Let's remember this students who agitate. That's why the cases are made against them. The council of our secondary party who have made the informant as a party. In that case, looting is not there. That's why.
Didn't mention the morning.
Or before writing, let's make also take up.
I'll just run through the list. Let us see.
Yes.
I'll just run through. Yes.
Item 5.
5. Non-APS in the interest of justice. Yes.
22.
I'm filing a memo for withdrawal, Your Honor.
Yes.
May be permitted to withdraw the liberty to file afresh.
That counsel for the petitioner seeks to withdraw the present petition with a liberty to file a better petition with the along with the necessary documents. With this liberty, the petition is withdrawn. You persuade them and file a consolidated petition.
Yes.
37.
May please your lordship. My lord, the petitioner approached before the court for modification of your lordship order. My lords have granted bail in respect of the present petition, my lord. But my lord, the so far is condition number 5, lordship. Lordship have passed the more than similar types subject to verification of more than one, my lord. That is, my lord, in the rejection order, it is reflected, my lord. That is one similar types of offense, my lord. My lord, lordship in the last occasions, my lords have queries whether it is a more than commercial quantity or the previous.
Have you filed any affidavit?
My lord, this is the, my lord, I am giving the, my lord, 6 grams.
No, you file the affidavit in the registry. File.
My lord, registry.
Counsel for the petitioner seeks
My lord, next.
we tend to file necessary affidavit.
Next week, lordship.
Release the matter after 1 day.
My lord, pray Monday, lordship.
No, he'll give it. This side of the vacation. Don't worry. Yes.
My lord is.
May I please, your lordship. Offense under section 302, my lords. The petitioner is in custody since 3/8/2023.
3/23.
My lords, nearly about 1 year, 4 months in custody. Now, the petitioner and the deceased, my lords, are two friends. Both of them went to consume liquor, my lords. They purchased cigarettes and disposable glass. After drinking, my lord, one of the present petitioner returned home, my lords, but the other friend didn't return home. Subsequently, it was found that he fell from the culvert and died, and the cause of death also is that.
Where is that?
The postmortem report I am submitting. He fell from a height, my lords.
Where is that? Death due to spinal shock. So, as a result of the mentioned spinal external injuries are antenatal in nature and could have been.
There is not a single eyewitness in this case, my lords.
Where does it say that?
My lords?
Where does it say?
My lords, he fell from the height, my lords.
Where is that?
The second point, it's there, my
Second one.
lords.
Death due to spinal shock.
Injury can be possible by fall from height. First point, last part, my lords.
The above mentioned neck injury can be possible by fall from the height. The question is whether you have pushed him or not. That is the question.
My lords.
Let us see if other evidence.
I have given the deposition copies of 6 witnesses, my lords.
What have they said?
Everyone is saying, my lords, they purchased those articles and went. Subsequently, when the present petitioner returned home.
That could satisfy the last in theory.
My lords.
And what else? Yes.
Under section 164, 3 people have specifically stated that those two were sitting together. Subsequently, they went there. Then at midnight, after in the morning 3 o'clock, so one of them, the present accused person, knocked at the door of the deceased person's mother and told her that your son is. I don't know where your son is. Then she, in fact, again told that I don't know, you people had gone, so how I will be able to answer that. So again in the morning, after around 8 o'clock, again he came back and got that your son, I don't know where your son.
He inquired whether he has returned or not, my lord.
Same person. This 164 he has specifically stated that Babula Reddy or Bibal Reddy asile hama dokan tanke dekhi to bhitare jhagda hela Babula Reddy.
They were both of them were together.
Where is the enmity then?
They were both of them were together.
Where is the enmity then?
They have taken the materials to drink, but there is no evidence on record. They were in drunken state or they have taken drink. From the shop they took cigarette and 3 empty glasses.
If they were not in good terms, where is the question of going together, buying liquor and all these things. There must be there good.
They have purchased.
He might have been shocked because after drinking he
My
fell down.
My
Who
lord.
knows?
And regarding PW2, my lords, in the cross examination, he has told that there was good relationship between my uncle and S. Diban Reddy, my lords, during the cross examination.
What is the motive? What is the motive? Have you got anything? There is no motive, nothing. He is already there in the
One more than
I
one.
beg pardon, my lord.
Yes.
One thing, my lord. In the meantime, all the material witnesses have been examined. Only doctor and I have to be examined. I leave it to my lord to dispose of the case within a time limit. Today, mother has been examined.
Mother has already been examined.
Nearly
There are two witnesses remain.
Only doctor and I have to be examined.
Total 31 witnesses, my lords.
The dogs.
31.
Total 31 witnesses.
Do one thing, your mother's testimony, you get it.
I'll get
Or day after tomorrow.
My lords.
Mother's testimony. Let us see mother's testimony.
Next thing,
Yes. Next will be there. Let us see if, from mother's testimony if anything. Because one thing is in the midnight he goes to the mother's place and says that
And we inquires about his.
what was the necessity to go to her place at midnight. Let us see how she is explaining. Yes.
42. But here, your lordship, I am in custody since 13/11/2023.
13/11/2023.
My lord will kindly turn to Annexure 1, page 7. The date of occurrence is 9/11/23.
9/11/23. 9/11/23. And
FIR was filed on
13/11/23. Okay. What are the allegations?
3761, 294, 506.
What has she said?
My lord,
164 statement recorded?
My lord, the evidence has been recorded.
Okay. Let us see the evidence.
My lord, may I kindly see the medical examination and then I'll take to your lordship's previous order.
Yes.
Page 36, your lordship may kindly see.
36. Okay.
Number 1, there is no bodily injuries on her person suggesting.
Let us understand what is the allegation. Then the question of bodily injury comes.
Then your lordship may kindly turn to my lord's order.
Yes.
My lord's order is at Annexure 5, page 45, your lordship may kindly see.
Yes. Annexure 5. Yes.
Paragraph 5.
Yes. This is regarding what? Whom?
Learned
Pinku.
counsel for the petitioner.
Pinku. Who is Pinku?
But the petitioner.
Okay.
Sole accused.
Yes.
Learned counsel for the petitioner is relying upon the medical documents which was conducted after 5 days of incident. It reveals there is no bodily injury sustained by the victim. Therefore, we submit that apparently there was no resistance from the side of the prosecutor, which led to the only inference that this may be a case of consensual death. But your lordship rejected my application because the victim was not examined. The victim has been examined as PW2 at page 48.
Come to that.
Lordship may see page 49.
Yes.
Paragraph 6. I am an illiterate. 8 years back prior to occurrence, I got married to Tikun Behra, a village such and such. 2 months after the marriage, my husband expired. After the death of my husband, I have been staying with my parents. Accused belongs to my village as well as my caste. Accused is married person having 3 children. I did not have any talking term with the accused. Police examined me once on the date of lodging of affair. The lady officer as well as the maid officer examined me. It is not a fact that I have stated before the police. The incident took place evening hour, time dark, nobody has.
What do you want to draw out of it?
My lord, I want to draw that she was a widow. There was relationship.
Where does she say that I have a relationship?
No, that
rather your suggestion that you had made statement to the police that.
My lord, whatever she said that she was subjected to rape, the medical report is completely silent. That's why I wanted to draw.
Now this is the allegation. And the fact that the petitioner is already in custody for more than more than one year. That is from 13/11/2023. I'm inclined to enlarge the petitioner on bail. However, on the condition that petitioner shall appear before the trial court without fail, even for once, even for once, apart from he shall be released on bail, there is deed patent proportion. Yes. Grateful. Yes. 43.
My lord, the present CRLMA has filed for restoration of the criminal revision number 17 of 2023, which was dismissed on 13/4/2023 on the ground of non-appearance of the petition.
Okay, restore to its original position, and yes, for the reason stated in the application, the it's a restore. Yes.
Item 44, that
Yes, sir.
the state was directed to obtain the up-to-date certificate. Against the confirming order, against rejection of application under section 457, thoroughly of the seized amount to the tune of 7,17,500.
Yes.
And that was affirmed by the revisional court, additional session is Kantawanji. The background of the case is that, my lord, at the instance of the petitioner.
Where is the order of the learned magistrate?
Annexure to
The
Page
operating
number
person.
page number 17, my lord. Running page.
No, this is criminal. This is revision.
Yeah. It starts from
Sessions, sir. Okay. Yes.
Page number 17.
The background of the case is that, my lord, at the instance of the petitioner, Turekela PS case number 17 of 2020 was registered.
Show me instruction. Yes. Yes.
Under section 394 IPC. While the petitioner along with others, they were moving from his village to a nearby village, there was theft, some mobile phone and some case to the tune of around 18 lakhs. Unknown affair was registered, but was ended in charge sheet on 23/6/2020, wherein the petitioner was shown as one of the accused. Charge sheet was filed on section 420, 406, 201 and 120B IPC. And a sum of rupees 7,17,500 was seized from my position.
Yes.
Selling the same, I file a petition under section 457 before the trial court.
What is the instruction?
Yes, my lordship. What happened? May my lordship, the kindly have belongs to the charge sheet. The charge sheet. Yes, my lordship. The relevant part I am reading, my lordship. During course of investigation, I examined the complainant and I have available witness and recorded their statement under section 161 CRPC. Visited the spot and prepared the spot map. Seized one Honda City 110 MC bearing registered number so and so, and it's wrong. During inquiry, it came to light that the complainant Manas Rana, his business partner Ishwar Meher and Gopal Machi made a conspiracy to misappropriate, cheated the money of their business partners and the cotton farmers and falsely lost an affair of Dakai. The petitioner himself is a complainant and registered the affair. Dakai at PS, so the case turned to under section 420, 406, 201, 120B IPC against them. So I seized two number of mobile phone, one Samsung mobile, model number so and so, and my mobile phone number so and so. From the accused Manas Rana, seized rupees 7,17,500 on production by accused Manas Rana from the house of Ishwar Meher, seized one Samsung mobile number so and so. Accused Ishwar Meher seized the transaction report of SBI account number so and so in the name of Ishwar Meher from the SBI Laptop branch. Seized 5 number of the money received from the Bajrangali cotton mill. Lapur in the name of Ishwar Meher.
You are going into the facts. What is your instruction? I asked you whether he can furnish bank guarantee or property security, release it. What will you do with the cash? Let him, he is a businessman, he will utilize that. He will secure it.
Yes.
As simple as that. Why you are going into so many things? What security you can give? Bank guarantee?
Or let's say property security.
Seek instruction. I will pass the order, then you move application for modification.
May prefer, let's keep it tomorrow.
Next week. You seek instruction, what security you can do.
Or let's keep it Friday, my lord.
Friday, okay, Friday. Seek instruction. Friday may not be possible. Then many matters.
Next week.
Next week.
Specific
instruction.
Yes.
You come and tell me, I'll modify that order.
Yes.
I release the cash. And you will replace by property security or bank guarantee, whatever they agree to. Bank guarantee or what?
Yes, my lord, bank guarantee.
Bank guarantee.
Okay. 16 pellet.
16 bank guarantee. 7 lakhs? 17,500. It is recovered from his position. He will secure it.
Yes.
Like,
Yes.
45.
Press notice.
Notice insufficient, huh? Notice not sufficient, press notice, yes. 46.
46.
Press notice.
Press notice?
let's see.
46 sufficient.
Yes.
Let's say petitioner filed this proceeding for questioning of this.
No, notice is sufficient, let us see, if anybody come.
You know the NI Act, the 490
47.
What are you?
46. 46.
46.
46. Dharanindhara Mahantam.
Complete. Notice on opposite party number 2 is sufficient, but none has entered appearance so far. In the interest of justice, one more opportunity is granted. Release the matter also to entry mode to continue. Yes.
47.
Yes. Appear, my lord.
Service? Huh? Not sufficient. Fresh notice. Yes.
My lord, I have prayer, my lord. The lordship may send for the mediation, and mediation will, because there is a possible settlement, my lord.
But the other side has to come. Once I issue notice, first day I could have done it. Now I issued notice, it is not sufficient. How can I pass an order?
So your lordship may have a glance to the IA, my lord, I filed with, my lord, because the
You first serve. Yeah, next.
Hello, for a moment, my lord, because the lower court is not giving the guarantee the time, my lord. That's why I filed IA, my lord. Your lordship can have a glance to IA. For the proceeding, my lord.
47.
My lord.
Yes. Yes.
I number 3239, my lord. And your lordship can have a glance to the order. 18 to 11 to 24, my lord. I'm supplying the certificate, my lord.
You have to file everything. All these things are creating a lot of problem. Now, have you seen the instruction?
My lord. So your lordship may stay for the proceeding, my lord.
No, how can I stay? First day I didn't say. Service is not complete. Now
no, what I am submitting, my lord, I am submitting.
Yesterday I didn't say means there must be something.
Your lordship may say I have
49, 48, 48. Press notice.
And my lord, just a minute. I am a player, my lord. So your lordship, I will file a, your lordship may direct, I will file a time petition that lower court will allow, my lord.
This is not complete. Why are you wasting time? File the fresh.
No, I will file, my lord.
Requisites, and this side of vacation I'll try to accommodate.
No, what am I?
Next, please don't waste time. Yes, next. Yes.
Sorted, my lord.
He'll give a sort.
So your lordship, I will submit your lordship because the.
Why are you, just see the time. Why are you wasting? I am not in the midst of the board. Let me complete. Wait, a lot of people are waiting. Why do you waste?
No, my problem is the court is not accepting my time petition.
You are concerned about your problem. You are not concerned about all of us.
No, my lord,
that's the problem.
No, the cross examination.
We concerned for other people also. Okay, next. 48. Yes.
Here I am bringing for questioning of the proceeding on the ground.
My lordship, matter was filed where the
Entire there was
yes.
Marriage has been dissolved by decree of divorce, and notice the lordship please to issue notice.
Notice what
Notice sufficient.
Notice sufficient.
Yeah.
When?
Item delivered.
When, just check it.
Noting is that item is delivered.
Let us see. Huh?
26/11, October 26, November 26.
Why SC is not cooperating? According to you?
So after the decree of divorce, I don't have any knowledge.
She has taken the alimony.
Yes.
she filed a matter before this.
No. Lordship, let me submit. The present husband filed a proceeding for resolution of the marriage. Marriage was dissolved by a decree which subject to permanent element of 2 lakhs. She preferred appeal before this honorable court. This honorable court, sitting in appeal in matter, announced the permanent element to 2 lakhs, from 2 lakhs to 12 lakhs. And the marriage has been dissolved. She has taken
12 lakhs. Yes,
while sitting with my lord justice.
And while taking 12 lakhs, is there any condition that he will?
No.
Okay.
Yes, my lord, there is judgment. My lord, I have annexed, my lord.
Page number 47.
Yes.
Yes.
The relevant part is my lordship. It's in 50 minutes.
Lordship.
15, my lordship. Mr. Mishra tenders 3 demand drop.
Yes, that I've seen.
Yes.
That I've seen. That I've seen. But it is a contested,
Yes.
contested.
Yes.
So she may contest also. Service is complete.
Because
Service on opposite party number 2 is complete. Despite that turn on appears in the interest of justice, last opportunity granted to the opposite party for appearance. Lease the matter also entry order to continue.
Entry order to continue. my lord.
First week of January कर दिया. Otherwise I'll call.
Entry order to continue.
Yeah, entry order to continue. Yes.
May I please your lordship? Lordship, I am in the base, my lord. Lordship permitted me to file the requisites by tomorrow, my lord.
Requisition not filed for last opportunity. ठीक है. Yes.
50.
My lord, may please.
Yes.
Notice was issued. I pray that your lordship may call it up.
I'm appearing, my lords.
He has already entered it.
I have been defrauded. He promised a marriage, cohabited, gave birth to a girl child. In a village meeting, he admitted.
You have a child.
Yes, he admitted that we belong to the same caste, same village, same clan. He admitted that I will marry her, but because he was unemployed or going to get a job, after getting a job, they will settle.
Has he got a job now?
Yes, and they will
That is
register the
exactly
marriage. In the petition, he has stated everything.
Yes,
Fairly,
that is petition.
excepting the main crux of the matter. How he registered the marriage, he made before the notary. Not
No, my lord, that is my submission as my learned brother.
But I don't want to go into all these things. Either you settle or face the trial.
My lord,
I can't pass it.
As my learned brother said, I have stated everything in my petition, starting from 164 statement
excepting
also.
that notary.
No, notary.
Not registered.
No, what do you want now?
Now, your lordship, I pray that since my learned brother has appeared, your lordship may kindly fix it to any date, short date even. I'll talk with my learned brother if it is settled because he is 19 years.
I have clear instruction. With he has under. If he is ready to marry, then
otherwise you face it.
That is exactly my lord. I'm only praying that let it come on any date. I'll talk to my learned brother. We have already.
These things, I'll tell you, in these things, if you delay, then there is a problem.
Definitely, your lordship. I only pray that let it come immediately after vacation. I'll talk to my learned brother.
Tuesday, you make a definite statement. Tuesday, you make a definite statement that you are going to marry or not. There is a child. Otherwise, I'll quash it, then you face the consequence.
Definitely.
Definite marriage. There is no question of no.
Yes,
no means dismiss. Yes means I'll try to accommodate in such a manner.
I have annexed everything in the petition. I have not suppressed anything.
Anyway, you see now he's there.
My lord.
There is a child. You can't avoid. Boxo is there, and who is going to quash it?
Because he is 20 years old.
20 that will be tested in the trial only.
Yes.
I can't
It
help it.
took time because the village entries that let him get employed. I will come back and marry. By then she was already pregnant.
You make a statement Tuesday.
My lord, my lord.
Make a statement. Okay.
Your lordship calling it on
Tuesday or Wednesday? When?
Wednesday.
Wednesday. Yes.
18th, my lord. Not 18th, 19th ko khali acha.
19.
Okay. Okay.
51.
The interim order may continue.
Interim order continue.
Even typographical mistake is been corrected 2025 24
कर देंगे.
and this matter may correctly be tagged with the item number 80 my lord.
80.
80.
80 सर टेप.
And then when we get the office.
इतना कर दो. ठीक है. Okay. 80. Tag with a item 80. Mr. Das name to be reflected and correction. Yes. Next.
May it please, your lords. May it please, your lords.
Yes.
Here, my lord, a FIR registered against 5 persons, my lord. The police investigated the matter and submitted charge sheet. 3 persons faced the trial and acquitted from the charge. 2 are absconded, my lord. Here, my lord, I am praying your lordship.
You are for these 2.
Only 1, my lord.
Then go and appear and face
Yes.
it. As simple as that.
Yes.
My lord, what happened?
I will not pass it.
Your lordship issue notice to the complainant and another victim. The complainant
I
and
am
victim.
appearing from complainant.
What are the offenses?
Offense is 395, your lordship.
Then
What happened, my lord? The complainant and the victim not supported the prosecution case. The independent witness 2 are also
They'll
not
do the
supported.
same thing again.
My lord,
Let them go.
in the deposition, my lord, they stated, we are not identified this, we identified this person, but they are not the accused. This is the statement, my lord. I am reading, your lordship, 34.
Why are they interested to come to this court now? Why have they come?
The present petitioner, my lord.
No. Why the informant and they are very much interested?
No, not
Let you
interested.
go?
My lord.
Are they necessary party?
Yes, your lordship. They are opposite party in this, not
Why
necessarily.
you made them party?
Because my lord.
Is it a 376 case or matrimonial dispute? What is this? In all other case, you only make the state as a party. Why in this particular case, you have implicated the informant?
Because my
in
lord, they are the
395 case?
victim, your lordship. Section 2
That means you own over this witness.
No, my lord.
Sufficient.
Section 2 VA of
That's
the CRPC, my lord.
obvious. Very obvious.
What happened, my lord? Your lordship, I am reading.
You are appearing.
Complainant, my lord.
Complainant.
What is your service?
Why have you given the complaint and thereafter you don't support? You have given the complaint?
TI period identify करनी. Page 30.
Complaint name FIR.
Name accused, your lordship.
Name accused. Why have you given the name then?
TI period my lord.
TI period is something different. You have named them in the FIR.
ଶୁଣିକିରି ଆଜ୍ଞା ଅନ୍ୟ ଜଣଙ୍କଠୁ ଶୁଣିକିରି ଇଏ ତ ଜାଣି ନାହାନ୍ତି ସେମାନଙ୍କୁ ଅନ୍ୟ ଜଣଙ୍କଠୁ ଶୁଣିକି ନା ଦେଲେ ଯେତେବେଳେ
you sufficiently managed. Go and appear. Since the other accused persons have already been enlarged, have been acquitted on the basis of that statements, I will protect you. Go and face the trial.
Your lordship, there is a NBW order.
I'll pass it. I'm saying
Your lordship.
That's the standard order I'm passing. I'll pass it and I'll allow you to go and appear and trial will be expedited. And
Order dated 7/6/2010.
But there is no question of quashing. Yes, petitioner is seeking which order you are?
My lord, in the IA number, your lordship.
No, the main petition.
I am challenging the proceeding in the CRMC, your lordship.
Here, page number 51, annex 5.
How many accused were there?
5.
5 persons are there, your lordship.
Petitioner is accused in FIR number 4. So one of
No criminal discipline is there.
One of the accused out of 5.
My lord.
One of the accused out of 5 in the FIR number so. Okay. And he seeks quashing of the entire proceeding. Entire proceeding on the ground that there will be 3 accused persons who have arrested. Face the trial and they have been acquitted by the trial court by the judgment dated 24/6/2024. Next slide. The petitioner along with the other co-accused persons have been declared absconded. Therefore, their trial has been split. At this stage, relying upon the judgment of the
Ananta Mishra,
ACJM, Special Judge ASJ Cuttack in ST case number 133 of 2010, Mr. Sahu submits that subjecting the petitioner to the trial is destined to be a futile exercise. Destined to be a futile exercise, particularly because the informant in the present case has not identified the petitioner. You were absconding.
No, my lord. What happened? In this case, we arrested. At the time of TI period, the complainant said these are not the accused. They are not the accused in this case.
And thereafter you absconded. Bail, you got the bail, thereafter you absconded. Identified the petitioner in the TI period. Subsequently, the petitioners were granted. Petitioner was enlarged on the bail, and he appears to have absconded. The informant has not only has made the statement before the court while in the ST case number. What is that? ST case number 130 of 2010. That he doesn't know this accused person.
Case number 34.
Person. He had the informant also in the present proceeding, which implicated opposite party number 2, reiterate his stand, stating that the present petitioner is not the one who has been who has committed the crime, committed the crime. I am not inclined to entertain this petition at this stage in view of the serious errors made in the FIR. However, keeping in view the peculiarity of the present case and of the considered review that the petitioners shall appear before the trial court on or before 31st of December and resort to the remedy available to him. He may move application before the trial court for grant of bail on all the grounds, including the ground that the co-accused persons have been acquitted, and also on the ground that the informant have not supported
Informant and victim.
Both of them have not supported the prosecution case.
So also the two independent witnesses also not supported.
Prosecution case besides the other witnesses independently. If such application is moved, the same shall be considered on the basis of the material available on record and on the basis and keeping like the observation made by this court.
NBW order term.
NBW is
order dated 16/6/2010.
Execution of NBW order dated 16/6.
17/6/2010.
2010
Oh.
is execution shall be kept in away till 31st of December.
Grateful, sir. Grateful.
Yes.
Somebody mentioned in the morning 72 and 74, 73 and 74.
Who will run through? Yes. 53.
Yeah, my lord, this is against the central government. The point here is that a complaint was initiated under the Payment of Wages Act against a shipping company which is registered under the Merchant Shipping Act. So two acts are involved here.
Yes.
The point that we are trying to make is that this prosecution, this complaint case is not maintainable against the petitioner.
Are you ready?
This is a central government case. They will
The central government. Point is very simple. They have launched prosecution under an act which is not applicable to us.
But
if your lordship wants, I can quickly run through the provision.
But no one is that. You have an interim order. None appears for opposite party number 2, opposite parties. In Mr.
My lord, is it a union opinion matter, my lord?
Yes, yes.
Which item?
Are you ready?
No, I don't know about this issue. These councils who are appearing that judge state penal.
This party appears for the Union of India and submits that he has not received the copy of.
Copy has
Along
been.
with Mr. D.R. Bhokta, let me reflect.
And Mr. G. Mishra, senior counsel, to supply a copy of the petition. This is the matter and so and so for the final disposal, and interim order passed earlier shall continue. Interim order कब pass हुआ?
Interim order was passed.
Date. I'll write the date. Otherwise, there is a confusion.
17/11/2015.
Interim order 17/11/2015. Shall continue.
My lord has directed for fresh copies.
Give a fresh copy.
I'll give you.
56.
My lord, item number 50. I am for the opposite party.
Yes.
Here the conviction
Who is
warrant
for
has been.
petitioner?
Well, my lord, friend is for the petitioner.
On behalf of Mr. Sharma, kindly 6 for adjournment for the meeting.
This matter has suffered lot of adjournments and conviction warrant has been stayed, though it is confirmed by this honorable court in a revision petition. My lord, at the para 3, everything is described in the RLMC.
Tell me, confirmed by this court?
This honorable court, my lord. in criminal revision 408 of 2012.
Yes, let us understand. Yes. What is this matter is about?
Well, it is arises out of a check bounce case, my lord, wherein an amount of rupees 32 lakh was awarded.
Yes.
After that, when two check bounce case was there, it was merged and a judgment was passed by this honorable court on 13/9/2019,
Yes.
wherein this honorable court directed that the accused is hereby directed to pay the rest compensation of rupees 8 lakhs within 4 months, hence, failing which would undergo simple imprisonment for a period of 6 months. And after that time and again, IA was filed for granting time. And the last IA which was disposed of, that is para 4, my lord, para 4, the second order. At page 5.
Page 5 of
the CRMC petition, my lord.
Yes.
It is quoted there. Considering the submission made and on going through the amendments taken in the petition, as also the earlier order dated 26/6/20, further keeping in view the acute COVID-19 pandemic situation prevailing for the quite long period, further 4-month time is allowed to the petitioner to make the payment in terms
So
of order.
total amount, how much you have received so far?
So far, except this amount, 8 lakhs, I have received other amount that has been admitted in the.
Hey, what is the total amount?
8 lakhs, my lord.
8 lakhs.
My lord.
32 lakhs he has to pay.
My lord.
Yes, sir.
The matter is being telling since.
What is the order dated 6/4/2021?
My lord, it is.
What is this order?
Page 16, my
Yes.
lord. Advocate for both the parties are present. Peruse the case record. Advocate for the convict files a petition praying therein that may kindly be allowed 2 months time on the ground stated therein. Heard both sides. Peruse the case record. It is seen that the order dated 22, order number 22 dated 3/12/2022 passed in criminal division number of Honorable High Court of Orissa, Cuttack. Further period of 4-month time is allowed to the petitioner to make payment in the terms of order dated 13/9/19. In the meantime, the above period of 4 months have already lapsed. In the meantime, the advocate for the convict files a petition for time which is heard and stands rejected. Issue warrant of imprisonment of failure to pay compensation under section 250.
How much intelligence you need?
My lord, this petition is pending since 2022.
22 we have taken time. So many time it has been extended. The trial court is rightly passed this order.
At least 1 week second.
No. I can't give that. You can't take a stay and see the stay order is passed. I don't know you are enjoying the stay.
Yes, ma'am, there is a stay order. That's the reason.
You are
They are
enjoying the
taking
stay
that.
from 22.
My lord.
After your conviction is confirmed and you have to comply the order. That's all.
My lord.
How can you take this is 138 case?
My lord.
After he owned the case, also he's struggling
Suffering.
since last 3 years to get his money back. Have you challenged that conviction anywhere else? That has become final. So then, I'll simply, on the request of the learned counsel of petitioner, the matter is adjourned to January 4th. However, the interim order passed on 10/5/2022 stands vacated. Yes.
Obliged.
Do whatever it is. Yes.
This 7.
This is a matter where on the same set of allegations, the inquiry under the POSH Act was conducted, and that has culminated with a finding on merits that the allegations are not proved. So, Your Lordship had posed the question to the state that after an inquiry has been completed under the POSH Act, how can this proceeding under the IPC be maintained?
Yes.
Which they are
Yes,
to answer.
Mr. Jana.
My lord.
This is like that Radhesham Kejriwal judgment. In adjudication proceeding, he is exonerated. Then no criminal prosecution lies. But exactly because this is a statutory inquiry. It is not a normal inquiry because after that act came into force, it has a statutory effect. Once that inquiry takes place, and he has been exonerated. On that basis, you can't prosecute. This is what I proposed you yesterday, last time. You just answer it. The analogy of Radhesham Kejriwal directly covers.
And the same point, the Karnataka, the Supreme Court had laid down that law, and thereafter it has been accepted by the Karnataka High Court directly on this point.
Yes, what do you say?
The judgment of
Who judgment? It's not prepared. I'll stay the proceeding then.
Your Lordship.
You keep on preparing.
Karnataka.
I'll stay the proceeding.
Karnataka.
The note.
Yeah, that is, he has acknowledged, but charge sheet has been submitted. But the point of law is whether after that exoneration, this criminal case can be.
Last time it was heard partly. I posed this question.
511.
Yes, I posed very specific question. I remember it. You should be ready. Otherwise, that is the reason I didn't stay. If you are seeking time, then I'll have to stay.
Lordship said, stay and keep a date, fix a date. I'll
Mr. Mukherjee, learned senior counsel appearing for the petitioner submits that the petitioner had undergone the rigors of an inquiry under what is that? POSH.
It is sexual harassment of women at workplace within bracket Prevention, Prohibition, Redressal Act 2013.
And the statutory committee, after inquiry, has exonerated the present petition. On the same ground, the petitioner is now subjected to prosecution in the what is that case? Subjected to prosecution in GR case number 18 of 2022. Notice was issued to the opposite side, opposite party. No, opposite party is there here? No. No, notice was issued on the state to address the issue regarding the
notice. The state को notice.
Notice was issued.
Yes.
Appeared. It was heard on the last occasion.
Just see, 9/11/2022. Mr. Naik, additional standing counsel, is directed to obtain the case diary.
Case diary is there.
Interception of the matter and to address the court regarding the effect of the inquiry report in under that POSH Act, under the POSH Act. Which general and counsel for the state seeks one adjournment for addressing the issue. These the matter shall say. In the meantime, the proceeding before which court? GMFC Kujong in GR case number 18 of 2022 is stayed till further so till and on the till further orders. Yes, state, yes.
The Lordship may fix a date.
He'll give a date.
Immediately after the voting.
Immediately after vacation, they give a date.
Yes. The person has retired from his service, he is unnecessary.
Chief Medical Officer of Coram Court Trust.
Let us see how it like that. Yes.
58. That it's a matrimonial dispute. Matter is settled annexure 2. I'm the husband. It was matter was settled by the dispute settled by the judge High Court Dhanbad. And in the order on the running page, your Lordship come to running page 16, finding the paragraph 8.
What is the position of service?
Position there is a settlement, 2.5 lakhs was paid. And
service in the
service notice and opposite party appeared. Advocate appeared, but last occasion your Lordship also order. If they will not appear once, then order will be passed.
It is made clear that negative appearing even if the opposite party number 2 doesn't appear. Yes. Show me in the judgment, show me that there is an agreement that it should be passed.
Page 16 your Lordship.
1/6.
Finding, yes.
Yes.
Running page 16.
Yes.
Paragraph 8. Poonam Devi, the complainant. PW2 is the wife and she has fully supported the corroborated the evidence of the husband, petition number 1 Satyendra Pandit, and has stated that she and her husband both have jointly filed
sued under 13B of the Hindu Marriage Act, and she stated that they are living separately since dated so and so. There is no way of physical reunion, and during the period there is no chance of reunion. She has further stated that as per the settlement, she has already received amount of permanent
She has
of
stated that
2.5.
except the present suit, there are two cases. So and where
Then running
they
to
have
70.
also settled their dispute right now. Petitioner at the instance of opposite party number 2, FIR number so and so came to be registered against the petitioner. On the ground of settlement, the petitioner has approached the court for quashing of the entire criminal prosecution arising out of Rahul Kala Mohila PS case number 6 of 2018. Notice was issued to the opposite party. Despite service of notice, none has entered appearance for opposite party. On the last date of hearing, this court, last date of hearing, that is on 28/10/2024, this court has passed the following. When the matter is taken up, none has appeared on behalf of opposite party number 2. Therefore, this court proceeds with the matter without waiting for the appearance of opposite party number 2. Mr. Jafarullah, counsel for the petitioner, submits that the additional principal judge, Family Court 1 of Dhanwad, has already passed a judgment dated, wherein the judgment dated 15/3/2022, dissolving the marriage between the petitioner and opposite party number 2. He has pointed out para 8 of the state judgment, which reads as another para 8. It has been agreed between the parties that all the cases pending interest them shall be put to quieters on the basis of the settlement there. It appears that the petitioner has already paid the permanent alimony of 2.50 lakhs to the opposite party. Since the opposite party has already received
2.5 lakh.
2.5 lakhs, 2.5 lakhs permanent alimony, and the marriage between the petitioner and opposite party number 2 has already been dissolved. The petitioner, the opposite party number 2, perhaps is not interested to participate in the proceeding. Moreover, where is he staying?
My lord, the wife is staying in the Dhanbad, my lord.
No, reverse.
My lord.
You are staying in Dhanbad.
I'm in the, my lord.
She is staying in Raulgarh.
My lord.
The petitioner is resident for Dhanbad. The matter has been pending since 2022 for quashing of the present matter is pending since 2022. Notice was issued to the opposite party on 15/11/2022.
She undertaken to withdraw the GR case.
She has also undertaken before the court below in the
last 2 lines
in the original suit proceeding number in the proceeding before original suit 546 of 2018 before the family court 1 of Dhanwad. Therefore, I am of the considered view that the petition deserves merit. Even in the absence of opposite party number 2, indulgence can be given to the petitioner. Even otherwise, subject since due to the non-cooperation of the even if the petitioner's case is covered by the judgment of Supreme Court in dancing and so vast. Yes. Yes.
59. Presentation of the husband. Should I prefer adjournment? Mother-in-law, sister-in-law,
on request, I can call. Yes. Okay.
60.
My lord, in last article, my lord directed me to file the list of event and
charge sheets had already filed it on December, 6th of December. Not with it, noting has come that is not this not been filed. I've already filed it as the receipt, and I have also served it to the
Learned counsel for the petition submits that he has already filed the copy of charge sheet and list all necessary documents as per the direction dated 19/11/2024, which has not come on record. Least the matter first week. The interim order passed earlier shall continue. Yes. Mr. Maharana, learned counsel for the witness submits that he has filed the objection to the petition. Copy of the same has been, advance copy of the same has already been supplied to him. Yes.
61.
I am appearing for the opposite part number 2, Your Lordship.
Yes. Who is appearing for petitioner?
Previous occasion, last two occasion, they are seeking adjournment.
Learned counsel for the petitioner has prayed for a adjournment on his personal difficulty grounds, or least the matter from so interim order to continue.
In previous last two occasion, there was no interim order continuation, Your Lordship. It was
no, last order there is a interim order. Therefore, I am giving. Last order there is. Yes.
62.
Any short, my Lord, can you take up next week, my Lord?
Let us see how we can adjust. Yes.
May I please, Your Lords? In this case, my Lord, the petitioners have challenged the order of cognizance, my Lord, dated 3/1/2023, my Lord, for the offense under section 498, 341, 323, 294, 506, and 34 of the IPC, my Lord.
Yes.
Here the petitioners are the father-in-law and mother-in-law of the informant, my Lord. And the main point, my Lord, that the FIR,
Service
in the FIR, my Lord.
Notice was issued.
Yes, my Lord.
I have entered appearance for informant, my Lord.
Yes.
Last time,
Settlement karo.
My Lord.
Settlement.
They say that's why, my Lord, he is not avoiding, my Lord, last 1 year.
I am not avoiding. What I am avoiding, my Lord?
Either you settle or I'll go dismiss either of these two. Because at this stage I'll not interfere.
Because the parents
for notice was issued.
My Lord, I have the. My Lord, I am the inverse, my Lord.
In the cognizance stage, I will not interfere. Settle the dispute. Matrimonial dispute. Why can't you settle? Today or tomorrow it has to be settled.
I am the third sister-in-law, my Lord. Because of the attitude of the parents-in-law, my Lord. And the
Parents-in-law.
third sister-in-law, my Lord. But the first, the son.
Lord, I am the father-in-law and mother-in-law, my Lord.
Two.
Whatever.
Twice he has
Why
get
can't you
divorced.
settle? Shall I send it to mediation or on
My Lord, mediation.
She may have to take. Settle what they're there. It is pending before the Rahul Kala.
I am sending it to mediation.
My Lord, my only prayer, my Lord, that the petitioner number 1 is suffering from urinary bladder cancer, my Lord. For which, my Lord, only his appearance through VC, my Lord, allowed.
Yes.
Yes, my Lord. How kichhe, my Lord, because
You may not appear. Send your son.
Yes, my Lord. My Lord,
Send your
only,
son. Why should you come?
Yes, my Lord.
Send your son.
Yes, my Lord. And my Lord,
Your
direction
son is
will be
not a
reflected.
party.
Yes, my Lord. My Lord, the
Your
direction
son
will
has
be
to settle with his wife.
My Lord, direction may kindly.
I'll just
the
so and so that appearance of our opposite party number 2. The present case is arising out of a matrimonial dispute, and the petitioners are the mother-in-law and father-in-law of opposite party number 2. Since the matter is arising out of a matrimonial dispute, I am of the considered view that the parties should explore the possibility of settlement through mediation. The parties are relegated to High Court Mediation. High Court Mediation Center?
Sundragarh
District Mediation Center. Sundragarh District Mediation Center. And Rahul Mediation Center. And the coordinator of Mediation Center shall fix a date and intimate it to all the stakeholder and explore the
son of the
exploring the possibility file a report. File a report before the which court is that? Before the court of STJM Rahul. Since the learned counsel for the petitioner submits that the petitioners petitioner number one is
One
suffering.
year is suffering.
Petitioner number one is the father-in-law and who is suffering from
Urinary bladder cancer, my lord.
suffering from urinary bladder cancer. And the petitioner number two is
Mother-in-law
old
lady.
lady up to 60 years. So therefore, they may not be insisted by the mediation center to APA, in APA personnel. APA personnel. I am in full agreement with the petitioner. Since the dispute is arising of matrimonial discord, it is the husband who has to, husband of opposite party number two who has to appear in the mediation center and explore possibility of a settlement with his husband. I'll dispose it up and call.
Yes, my lord.
Yes.
My lord, family court case is going on. Settlement mediation he already.
Again, you,
Family court he is
again, you
giving.
authorize.
Yes, my lord. Then MNA in-laws, my lord. Say my lord. He's giving maintenance, my lord.
These are relegated to mediation, relegated to mediation center. The proceeding before the court of SDJ, 1 minute, arising out of Panpos at Auralkala in GR case number 1371 of 2022 that remains stay till the mediation process is completed.
They will not protect my lordship that. Otherwise, they will protect the litigation.
And it is made clear that the parties shall not unnecessarily procrastinate the mediation process. The matter is with the aforementioned observation, the matter is disposed of. The liberty is granted to the petitioner to renew the prayer if cause of action at any stage survives. So with this observation, petition is disposed of. Yes. 63. I have disposed of.
Yes.
Your mediation fails, then you have a right to file fresh petition. Yes.
Sir, here can the husband is not party. Say
I know. Therefore, I have said
yes,
husband is to participate.
My lord.
Item 63, my lord. In this case, the brother-in-law challenge, he quashed the DB proceeding as because by way of a compromise, my lord. Husband to appear and file judgment of a matter case number.
Yes, madam. Settlement is there.
My lord, we have no objection. I am on behalf of Mr. Behra.
So what do you want now?
We have no objection. We want to quash. Already settled between the parties.
So, shall I quash it?
My lord.
Huh?
My lord. Matter 246 in Matter 246.
So where is that settlement procedure? Annexure?
Annexure. Typed by the husband.
You have settled the dispute, huh?
My lord.
Marriage already dissolution.
Marriage dissolved. Yes. Who are the petitioners?
Brother-in-law.
Petitioner is the brother-in-law of opposite party number. Opposite brother-in-law who is Namrata.
Opposite party number 2 husband, 1 wife.
Okay. Petitioner is the brother-in-law of opposite party number 2. Whereas opposite party number 2 is the husband of opposite party number 1. At the instance of opposite party number 2, the DV proceeding, DV case number 83 of 2023, before the SDJM Jajpur has been initiated against the present petitioner. Petitioner is seeking quashing of the said proceeding on the ground of the settlement. The dispute is arising out of a matrimonial discord and parties have arrived at a settlement. On the basis of the settlement terms, the petitioner had who is Devasis? Devasis is petitioner had moved this court by filing CRLMC number 3602 of 2024 for quashing of the Sukinda PS case number 121 of 2024 initiated against him by the opposite party number 1 for alleged commission of offenses under section 294 to 323 498A 34 IPC. This court by order dated 29/11/2024 has been free to has allowed the petition and quashed the entire proceeding on the settlement terms. Relevant part of the said judgment reads as under para 2, 3. Para 2 and 3. 2, 3 and 7. And for 2, 3. Para 2. Relying upon the settlement term, the petitioner submits that the present petition declares merit and it may be quashed. So and so entered appearance. And you have filed counter affidavit opposing or what? The opposite party has filed represented opposite parties are represented by so and so. And a counter affidavit has been filed. The counter affidavit dated 27/11/2024 has been filed. In the said counter affidavit, the petitioners, the opposite parties have also annexed the judgment of the order dated 21/11/2024 passed by the division bench of this court in Mata number 261 of 2024. 2024. The result of relying upon the said order, both the parties constantly submits that the dispute has already been settled amicably. Hence, the proceeding arising out of DB case number so and so it may be withdrawn regarding to the aforementioned the proceeding arising out of DB case so and so is quashed. Yes, this was the question. Yes.
Item 68. Item 68.
71. Next week on any day.
Adjournment, if there is no urgency, the matter will go beyond vacation. If there is urgency, then we will adjust before vacation. All the
items.
And wherever there is an adjournment, if it is not a very old case, it will go to March.
My lord,
It
138.
is not an old case. If for the old case, interim order is
Interim order is there. my lord.
he'll try to put it this side of the vacation or immediately in January. This is
This item 70, can you let you tomorrow day after?
and that he will do it.
Yes.
So that students matter.
Item 70, that students matter. Can be
That's what I said. If extreme urgent matter, he will put this side of the vacation.
Yes.
This side. He'll do it.
74 mentioned in.
Can it be Friday, my lord?
It did to 16. So interim order is continued because there are applications for adjournment in grant.
Okay, interim order 72, 73 interim order to continue.
73, 74.
73, 74 interim order to continue and put it immediately after vacation.
By 8 to 2 p.m. my lord.
Yes.
Item 68 by letter trade made a submission.
Item 2 p.m.
Mr. Pali. There, yes, let it come any day suits my lord's prayer. But my only prayer is there is an interim arrangement, let that continue wherever matters come.
Let it continue.
I can pray for that. Right. Any day come. Interim arrangement is there.
Any day means one day before vacation or after vacation. You want.
This side of the vacation.
This side of the vacation put try. The problem is issue is same.
I have no choice. Any day that
That's the only
to
difficulty.
continue the trial court is pressing hard.
40 plus urgent matters every day. 40 plus and specific urgent matters every day. Plus bail matters are there.
That's the whole difficulty is every day there are 40 plus
But I don't want.
specially fixed matters and over and above that bail matters and all.
Let it be the reopening, Lord. Let it be the reopening week. I leave it to you, Lord.
Reopening the first week of the reopening.
My lord, item 60.
Interim order to continue.
Item 60.
60.
My lord, item 66, 67, my lord. Last occasion, your lordship heard it and fixed it to 4th December. But it could not come again on mention it came. I pray let it come 17th or 19th any day, my lord. Interim.
I will not say anything. He will have to adjust everything. I told him that at least about 100 meter I am trying to take. If there is a distraction in between.
Asking the opposite party, the matter should be reviewed as cross-examination has been denied. The opposite party denied on that was picked from 16th December. That's in the report is not.
Just He can only adjust the dates. I don't know how can I do it. Now, what do you want? Why can't he take an adjournment? Otherwise, his matter will be infructuous.
I am ready to take court matter for the cross-examination of
Cross examination of whom?
PW1 and PW.
PW1 and 2, who are they?
They are the compliance in before law.
No. And then what are the offenses?
Offenses, 145.
145%. I'll allow it subject to cost. Huh?
With cost.
With cost, how much? Let it be 5,000 cost. Okay. But then pay 5,000. 5,000. Huh? No, 5,000.
I don't say.
60?
65.
65. Give it to me. Huh? I'll just pass and all. I'll pass it. Allow it. Okay.
72.
And give your appearances.
Item 72.
Yes. One opportunity. On the same day you conclude, pay 5,000. Yes.
Item 72, my lord.
Both the PW1 and PW.
Both.
72.
He doesn't have objection. Yes.
Item 72.
72. Yes, sir.
That is a matter, my lord, it is very small matter. My lord, the gold ornament mortgage before the bank is directed.
I know, I asked them what instruction you got, that gold ornament thing. Somebody mentioned it, got urgent. I don't know.
I only press on it because
We'll see what.
Because of that,
I don't know. On behalf of you also. Yes, Mr. Mr.
Before vacation,
71.
There is a small matter relating to 138 Act. It can be disposed of within.
You are for accused.
My associate name is there.
Well, give a date.
Another small matter, criminal office. Because hard by you also one or two.
You now you see the position you are talking about AP. That's right, but what to do? See, it should be humanly possible to take it up.
That is correct.
That's the whole difficulty. Otherwise, I am trying to take as much as possible.
But that is your lordship.
I know that I vigilance side. You asked Mr. Das is there. Couple of matter partly heard and we are not able to reach there. That's the difficulty. We'll see what can be done. We'll see what can be done.
Otherwise, I would not have insisted upon, but many matters are there.
That must be there in the weekly list. Including the weekly list, let us see. At least let it come in the weekly list. We'll see. Yes. Any mention? Yes.
I'm not the case is pending since more than 30 years. Not more. It will be taken up.
It is CRLMC of 2024. I am not responsible if it is pending somewhere else.
And this for passing of the entire proceeding.
We'll
Any
see.
date in the
Give. Okay. Thank you very much.